when is the interim order
My
expired?
lord, it has already been expired on the last day of the previous circuit, my lord.
You make an application.
Sorry.
You have to make an application.
The CRAN one has already been filed, my lord, just because it was the last day last day of the previous circuit, so that's a matter was not taken up, my lord.
No, can't be helped. See, you have allowed the order to expire. There is no urgency as such. You give this slip, if it appears in the normal course, we will take it. Upon notice.
Notice.
Sorry.
No, my lord, verbally we have.
No verbal notice. I don't believe in this verbal notice business.
Oh, sure.
Item number 1, under arbitration.
My lord, I appear on behalf of the petitioner, my lord.
Yes?
My lord, I appear, my lord.
On behalf of?
My lord, the petitioner, my lord.
Yes. What is the matter about?
My lord, my lord, an application under section 11 of the Arbitration Act was filed, my lord. Meanwhile, my lord, there was a corporate insolvency resolution process that has been initiated against the respondent one, my lord. Hence, my lord, on the previous two circuits also, previous two occasions when this matter was taken up, my lord, we were pleased, we had requested the honorable judge, my lord, to send the matter out of the list, my lord, because that is pending, my lord, before the NCLT, my lord.
See, the difficulty is that you have to satisfy me on two counts.
My lord.
One, in case of winding up proceedings, previous concept, winding up proceedings, arbitration was maintainable.
My lord.
Now today, under section 95 or section 101, whatever may be the moratorium, to what extent it goes against you?
My lord. Now, my lord, what has happened is, my lord, I fairly submit, my lord. My lord, Mr. Ghosh is the arguing counsel in this matter, my lord.
Which Mr. Ghosh?
Mr. Shubham Ghosh, my lord. My lord, he was here, my lord, he was here yesterday, my lord. My lord, today he has traveled to Calcutta, my lord. My lord, he'll be here tomorrow morning, my lord. Kindly, my lord, takes this up tomorrow.
Yesterday it was called on, no one appeared.
My lord, then, my lord, I'm aware, my lord. We had entered, my lord.
No, tell me, he was here yesterday, he did not feel it fit or deem it fit to appear. Today he is not there. Today you are asking for, you say that he will be back tomorrow.
My lord, he'll be back tomorrow.
Tomorrow, same thing will happen.
No, my lord, no, my lord. I assure, my lord, I give the assurance, my lord, nothing will, my lord, will appear, my lord, and he'll, my lord, clear all the doubts with regards to that.
Because you have to satisfy me that to what extent.
My lord.
See, moratorium means what?
Yes.
You cannot proceed against them for enforcement any order. Now, arbitration till a decree is passed or an award is passed, it does not amount to passing of a order which can be coercive against you.
Yes, my lord.
Now, does the moratorium allow that no proceedings shall be initiated, including arbitration?
I have to look into it, but I'm not aware of that.
Very good.
My grateful.
Not today, tomorrow.
Item number 2.
Lord, item number 2, I'm for the petitioner.
I'm for the respondent led by Mr. DSJ online.
My apology, my lord, I could not be present yesterday due to certain.
Yes. What is the matter about?
My lord, this is in section 11 arbitration application for appointment of arbitration. My lord, there was a precondition in the, my lord, this is the dispute between a contractor and a railway contractor and the Department of Railway, my lord. Now, he has done some works, railway is not releasing the payments. So he has given certain notices, kindly release my payments. That was done. They did not release the payments. So he invoked the pre-arbitration clause. The period of pre-arbitration was 120 days, my lord. In that period also, no steps were taken by the railway authorities. that constrained the petitioner to approach this court by way of Section 11 application, my lord. Now, after we filed the Section 11 application and served it upon the respondent authorities, my lord, that is the general manager, the department, they started certain internal acts, my lord, and they asked the petitioner to come before them. And they said, we will negotiate. And since then, my lord, he has been traveling from Guwahati to Katiyar and Guwahati to Katiyar.
No question. See, this issue has been settled long back. Data switch here, long back. That yes, the 30 days period under the Arbitration Act, within that you can appoint an arbitrator. If you fail to do so, the court will appoint. Mr. Mojumdar,
Lordship, the main problem is my learned friend just served on the department has not given me a copy. And if he is kind enough to supply me a copy, I will go through it and take instructions and get the matter resolved.
it's
Because
not
if the
see,
contract contains a clause of appointment of arbitration, the railways have to.
Mr. Mojumdar is neither here nor there. If your client has not given you a copy,
No, my lord, if there is a statutory contract, the client has to. I will advise them. I will prevail on them. But he is not giving me a copy. That is the most biggest problem.
it is not required. Why should he give a copy to you? Why should he, your department has received the notice?
My lord, kindly recalls the three-bench judgment of the Calcutta High Court presided over by Honorable Justice Samazdar, where his lordship, the three judgment had held that certifying on the both service has to be done.
No.
This is not a writ
I was,
petition.
I was part of, I was.
Yes, your
part
lordship was a
I
part
was
of that.
part of, I am very much aware.
And
The
my lord,
service-
it is
the
for his
service-
benefit. I am
the-
asking.
The service on the government pleader or the ASG is an additional service.
Lordship.
Because Arbitration Act is very clear.
Private.
Even the award has to be served on the party concerned.
My lord,
Service-
I am asking a copy for his benefit. Now, if this
My
technical
lord, I
thing
can
come
serve a
into
copy.
way,
That is not a difficulty for me.
you could have done this long back. I could
No, my
have
lord.
sought instructions.
Very well.
I guess Mr. Singhal wants to drag the matter, my lord.
No, not at all, my lord. It is the railway who is asking my party.
Mr.
to go
Singhal
to-
crosses me every day, my lord, in the circuit bench 10 times at least.
My lord, I'll hand over the copy today, my lord. It can be fixed any day this week.
You are coming on
Monday, my lord.
very well, Monday.
If your lordship desires, I am now fit for traveling. I can come down tomorrow also, my lord.
No, you said two of your matters have been fixed tomorrow.
I will come down, my lord.
কালকে না পরশু এই সোমবার রাখুন।
Grateful.
Deeply obliged.
Item number 3 under civil motion. Item number 3.
Lord, I have considered the judgments which was indicated by your lordship,
It is 2006 or 2008.
2006. Lord, 2006.
You will find a tabular, in a tabular form, it was given 227 and 226.
But 2006 judgment, however, my lord, Justice Sinha's judgment, my lord, this does not, there is no tabular form although, if this is the correct one. So far, 27 is concerned, my lord, there is a 2015 judgment of Justice Adarsh Goel.
Hmm.
My lord must be conversant with him, my lord, this distinguishes 226 and 227 further.
No, this is not the judgment probably. In 2006, there were two judgments. This is one, but that 226 and 27 is a different judgment. There, it has been given in a.
If Millet intends to have a look at this, Millet, this is 2015. 226 and 227 has been Millet elaborately discussed and distinguished.
Yes.
So, my lord, my respectful submission is that here, since an order of the DRT is impugned, so my lord, probably 226, my lord, in exercise of original jurisdiction of the High Court in the nature of a writ of certiorari, that may not be appropriate. It has to be under 227 under the supervisory jurisdiction to set an error if your lordship feels that an observation is incorrect.
So now, going down from this judgment, it has been clearly said that in respect of private disputes, civil courts order.
Yes.
Now today, the Debts Recovery Tribunal Act or for the Servicing Act, they are promulgated by the legislature. But these nationalized banks, they function under the guidance of the RBI.
Yes. Yes. Amendable to Article 2.
Article 12.
Yes.
The distinction you will find in Sagar Thomas and subsequent judgments where service matters relating to
Yes, yes.
banks,
Yes.
what will be the
If there is a RBI, they're governed by any statute or regulation
now,
which has a.
in case of transactions,
Yes.
when the transaction is made, suppose I borrow money from you. You are a financial institution or a bank. So vis-a-vis you and me, it may be a private contractual issue. But when you are functioning as a nationalized bank under the guidelines of the Ministry of Finance and the Reserve Bank of India, whether your actions can be gone into in 226 or 227. If you look it from the angle lender borrower, contract, failure, simpliciter, private dispute relating to money or loan. But the overall control of the bank is with the RBI or the Ministry of
Yes.
Finance.
Yes.
Then what will be the, because then this judgment will not help you out. On the contrary,
What-
the contrary, if you come to the judgment quoted just before the conclusion,
Yes.
paragraph 64, 65 is quoted, you find this is quoted from Shalini Sham Sethi.
Yes, I'm carrying that out.
You will find that we would like to make it clear that in view of the law referred to above, cases of property rights and disputes between private individuals, writ court should not interfere unless there is an infraction of statute or it can be shown that a private individual is acting in collusion with a statutory authority. We may also observe that some high courts there is a tendency of entertaining petitions under Article 227 of the Constitution by terming them as writ petition. This is sought to be justified on erroneous appreciation of the ratio of Surjo De and in view of the recent amendment
To section 115 of
15
the
of the
Civil Procedure Code by
it
the.
is urged that the reasons of the amendment scope of 115 CPC have been curtailed. In our view, even if the scope of 115 CPC is curtailed, that has not resulted in expanding the High Court's power of superintendence. It is too well known to reiterate that in exercising its jurisdiction, High Courts must follow the regular, the regime of law.
Regime of law.
These are the, so
But
what
that-
is your challenge here? What is your challenge?
My challenge is the order of the DRT. The DRT
So far
says
as the order of DRT simpliciter 227.
227. So had it been any action of the bank per se, my remedy obviously would have been under Article 226. Now, since there is a judicial order in between, that subject to correction, it has to be, it can be under 227.
What is the subject matter of challenge?
Subject matter of challenge is Millard. The
Who is appearing for the respondent? No
it's still in the admission stage. It has not been admitted. So, Millard, should I serve and come back?
one. Let me hear you
Yes.
just.
I took a financial assistance by mortgaging a particular property. Mortgage was created by deposit of title deed. Now, the property described in that schedule is with specific plots, specific boundaries, specific quantum. Now, I repaid the loan. The property was given back to me. Millard, I stand corrected. I failed to repay the loan. That property was put on sale. Now, the purchaser, the auction purchaser of the property went to the plot, took physical possession. Matter ends, the sale proceeds which were received was adjusted with the outstanding liabilities, and the balance was debited back to me, credited back to me. Matter ends. Now, after a few days, once again, I suddenly receive a loan recall notice, an advocate notice saying that that property which the bank had taken possession of could not be delivered to the auction purchaser due to lack of possession, or it was encumbered somehow. Then they again started a proceeding against me. Now, this time, they went, the proceeding started in the DRT. I appeared, I said that whatever has been mortgaged, except that you have no rights against me, you do whatever you do because you have already taken possession at your own satisfaction. Now you cannot turn back and chase me again. Then DRT passes an order that that property which was earlier mortgaged, bank has every right to proceed against them. And another further observation by which I am aggrieved is I cannot sell, dispose of any other properties belonging to me. That particular provision, paragraph in the order is what, Millard, I found to be palpably erroneous and, Millard, amendable
Which is the
to.
bank?
It's Indian bank. Earlier, Millard, it was probably Allahabad Bank. If Millard kindly takes the impugned order
Do
once,
one thing, you serve and come back.
I will serve and come back.
Monday or Tuesday, tell me.
Millard, today is already Thursday, Millard, if it can be Wednesday. Wednesday.
This is an application filed by the borrower challenging the order passed by passed by passed by the Learned Debts Recovery Learned Debts Recovery Tribunal Shiliguri in EOA number 371 of 2017. ওই 10 January বলেছি 10 January order dated 10 January 2024 passed in EOA number 371 of 2017 arising out of way number 258 of 2015. It is submitted by the petitioner that the default committed by the petitioner in respect of a financial assistance availed by him has been set to rest after the property mortgaged for availing such financial assistance was sold in auction and the possession thereof being made over to the auction purchaser. The petitioner has the bank and the opposite party bank after adjusting the outstanding amount had returned the excess sum from out of the sale proceeds to the petitioner. Subsequent thereto, the bank has again initiated a proceedings on the allegation that the property given as security allegedly being encumbered would not be allegedly encumbered. The physical possession thereof would not be made over to the auction purchaser. In the subsequent proceedings, the order dated 10 January 2024 was passed, which is the subject matter of challenge. না কি বলেছি কি
Subsequent question, the order dated 10th January 2024 was which is the subject matter of the adjudication petition.
It appears from the said order. Which page is the order, Mr. Ghosh?
The
Certified copy.
certified copy, Millard would find page 9, internal page 9, observation 3 and observation 4, Roman 3, Roman 4. Roman 4 is what Millard I am agreed with.
Paragraph.
Millard, internal page 9 of the impugned order, Roman 3 and Roman 4. Roman 4 is what I am agreed with. Millard would find or any other property and assets belonging to the
কি
defendant.
বললাম
Yeah, appears from the schedule.
that the defendant is debarred from transferring, alienating, encumbering or disposing of the hypothecated mortgage properties or any other property and assets belonging to the defendant till the aforesaid adjudicated debt amount. এটা অ্যাকচুয়ালি এখান থেকে ওইভাবে করে দাও, তাহলে আর সুবিধা হবে, অতটা লিখতে হবে না। ওখানে প্রথমে কি বললাম?
Yeah, appears from the schedule.
It appears from a portion of the said order as follows. বলে এখানে এই set out portionটা the petitioner is aggrieved in respect of the and even the petitioner is aggrieved
In respect of
uh, being debarred from transferring, alienating, encumbering, or disposing of any other property and assets belonging to the petitioner till the adjudication of the debt amount. And its recovery takes place post. Let a copy of the application be served on the opposite party bank. Let this matter appear on বুধবার কত তারিখ হচ্ছে? হ্যাঁ 18 তারিখ, তাই তো? ঠিক আছে।
But, can I pray for a protection, no coercive action?
No.
Please?
Not at this stage.
I'll pray for that on the next occasion. Let them. Grateful.
That's the reason I have asked you to serve a copy.
Grateful.
Item number 4.
My lords, I beg to appear, my lords, for the opposite party.
Who is for the petitioner?
Milord, I'm for the petitioner.
Yes, what is the matter about?
Milord, I'm led by Mr. Seth from
Mr.
Gujarat. He's appearing online, Milord.
No, ওটা আলাদা।
Lordship,
এই দুটো আলাদা আমার কাছে।
am I audible, Lordship?
Yes, yes.
Lordship, I'm appearing for Mr. Shade. Yesterday, Mr. Shade's mother went undergone a surgery, and there are some complications. He is in hospital since yesterday night. So, can I request for some time in that?
My lords, may I say this? My lords, I have no objection on personal grounds, but my lords, this is a revision against rejection of a Order 7, Rule 10 that they filed after 13 years of filing of the suit. And my lords, last two occasions, your lordship will see the orders. They've sought time, my lords, naturally, my lords, because they want to keep this pending, my lords. I just want to say that, my lords.
Can I indulge in that? Lordship may see the first order. These are first May 2025.
What is
There
the
were
suit
elections.
about? What is the suit about?
The
My lords,
suit
this is
about-
my recovery
is
suit, my lords. A money claim has been made. And I filed that in 2013. In 25, my lords, they filed a 710 saying that the invoice says that the jurisdiction of Ahmedabad court is mentioned and therefore the suit doesn't lie in Siliguri.
So my friend is misleading the court. There are cross suits pending. One is in Ahmedabad, one is in Siliguri.
Please don't use the word misleading the court. It is a harsh word.
I apologize.
When you are in rope, don't allege this thing against somebody who is also on ropes. Please use that. It's not properly instructed.
I apologize. Can I put the correct facts on before your lordships?
Yes.
Okay, there are two suits pending before. One is in Ahmedabad City Civil Court and one is in Siliguri Court. The Ahmedabad court is prior to Siliguri Court. Now, what has happened? The Ahmedabad court's matter went into the stage of issues, and thereafter the suit was filed in Siliguri Court. My submission before the trial court was that the suit is barred on the plain text to be returned for filing before the appropriate court, and there also the cross suits are pending. So for that we have challenged that order before this court.
If cross suits are pending, why didn't you go for Section 10?
Lordship, I filed Order 7, Rule 10 on the pretext that the clauses in the invoice, the purchase order doesn't say anything on the jurisdiction. The clauses says that the parties have to go to Ahmedabad court for any problem regarding the transaction.
It is well settled now that Swastik Gas, 2013 Supreme Court,
Yes.
that if there is a jurisdiction clause even in the invoice, the previous view, right, starting from ABC Lanyard, Moga Transport, then Silpur Paper Mills, all these were that exclusive only words have to be used. Now, Justice Rumapal, sitting in the Supreme Court for the first time, in Man Roland, 2006 Supreme Court, said that if the parties have chosen for a particular jurisdiction, even if the words only exclusive is not mentioned over there, it should be construed that the parties agreed to exclude the jurisdiction of all other courts. Now, this view was considered in Swastik Gas, and Swastik Gas clearly held the exclusive words, and these are not required. Now, there are at least 3 judgments, if I correctly remember, in a very recent judgment of mine, delivered in the principal bench. I have considered all these judgments, Viom Mines versus Jharkhand Ispat probably, where the tax invoices contain the jurisdiction clause. Now, if nothing has happened within the jurisdiction of this court, or parties have by the tax invoice accepted a particular jurisdiction, then the parties should be relegated to the said jurisdiction. Now, if you go by the provisions of CPC, Section 9 and Section 16 to 20, then you will find that ordinarily a suit will lie where the defendants are residing or working for gain or ordinarily carries on business. So going by this, if you look into the Siliguri suit, you are stationed in Siliguri.
I am stationed in Ahmedabad, Your Lordship.
You are stationed in Ahmedabad.
Yes.
And there they say that they are stationed in Siliguri. A part cause of action in respect of the transaction has taken place in Siliguri.
Please, Manoj.
Now, two issues. First, after the promulgation, what is the value of the suit?
Because this is above 2 crores, the claim is about 2.5 crores. So this is a commercial dispute and has been transferred now.
Oh, transferred to the commercial court. That's
Please,
what the inquiry. So now the court has found that no, the Order 7, Rule 11, Rule 10 application is not maintainable. So
Please,
against that you are coming.
Please, Your Lordship.
I do not know why the Order 7, Rule 11, Order 7, Rule 10 application was made, because if the suit, Ahmedabad suit, in respect of the same cause has been filed prior to this suit, then under Section 10, this suit has to be stayed.
No, Miloj, may I say this? They filed a suit in
Lordship.
2012. I filed a suit in Siliguri in 2013. Miloj, their suit was dismissed for default, Miloj. I continued to pursue the suit.
I may intervene.
One second, Mr. Somraj, you'll get your turn. I continued to, Miloj, pursue the suit. They filed a written statement. That written statement, Miloj, is on record. They don't take this objection on jurisdiction. After that, Miloj, issues were framed. And Miloj, the suit was then, Miloj, proceeding ex parte because they chose not to appear. Then, Miloj, the Commercial Courts Act was promulgated. The suit was transferred to the Commercial Court. They were again served summons. At that point, Miloj, they appeared and they have now filed a 710, which was considered by the learned Commercial Court and dismissed, Miloj. And in the meantime, Miloj, they have revived their Ahmedabad suit. And I have the copy of the plaint, Miloj. In their suit also, Miloj, they don't make a single averment that Ahmedabad court has exclusive jurisdiction. That plaint is, Miloj, available for your lordships to consider.
Now may I submit something?
I could have disposed of the matter here and now, but since one advocate is involved,
very well, Miloj,
whose mother is unwell, I am not willing to deal because no point.
No, Miloj, very well, Miloj. I am not objecting to that, Miloj.
I am keeping it on Monday. I think by that time, by God's grace, the council will be free so that we can.
Please, my lord.
Lordships, in that event, can I make one more request?
What?
Since I was informed for taking a date of next week, I'll ask for Monday after this hearing is over, and I'll ask my that local advocate, Mr. Somraj Paul, to give a cheat to the court master subject to convenience of my learned friend and towards the court. If not Monday, then.
No. I hope.
Or lordships may take up one more matter, and thereafter I may tell the date subject to convenience of this court.
See, today we are on Thursday. We have 4 days in between.
Fair enough. I am having no objection.
I'm keeping it on Monday.
Monday, please, your lordship.
Grateful, my lords.
With the permission, may I leave?
Yes.
I'm obliged. I'm grateful.
Item number 5.
Item number 5, I am here, the issue is involved, lordship. Revisional application has been filed. Yeah, the petitioner has been preferred a application before this rent controller under section 21 with a prayer to deposit the rent on being refusal by the opposite party landlord.
On being?
Refusal by the opposite. And
So you did not go, you asked for time yesterday.
yes,
when I was
my doctor has been fixed me to 2 p.m. That's why I come to office. 2 p.m. I had 12 I came. So lordship, therefore, your honor, my lord, the petition that has been filed, they have been appeared and that has been contested. Suddenly, lordship, in the prior to that, lordship,
affidavit of service. ও ঠিক আছে দাঁড়াচ্ছে তো আলাদা। See, let us get it one by one. An application was made before the rent controller by the tenant for depositing the rent.
on being refusal by the.
Very good.
And thereafter, the case has been filed in the year 2021. And the case has been running by they have been written objection. In the year 2025, that is in January 2025, the controller was pleased to drop the case by 5 lines order. Lordship, the order is in a fashion, lordship goes the order and last part.
Yes.
That is been ordered, 2 days fixed for hearing. The case record is put up. Both parties filed hajira through their learned advocates. Timeline has not been adhered. Hence, the case is dropped. All concern is in purpose.
Yes.
This is lordship, the order. Now, lordship, my case, shades of the petitioner in my case is.
You are the landlord.
I am the tenant.
You are the tenant.
My friend is a landlord. Now, lordship, the case actually, in respect of the premises tenants care, if the order any order final order being agreed, person should go to premises land tribunal. That has been law. Now, lordship, if we are go to the section 43 of the Premises Tenancy Act, this is really a final order. This is written, my lord has known that is in final order in respect of final order. A person should.
This is not a final order.
This is not a final order. My lord, I'm coming on that point because of the final order itself is it should be must be clarified the right of the petitioner while as established or refused that has been not been stated. Is the petitioner, is the tenant is able to deposit the rent or refusal? That is
a Premises Tenancy Act দাও তো 90 I have a copy.
Lord, kind of section 43. Can you Section 43, Lordship.
Just a minute.
Shall I read?
Just a minute, just a minute. Yes.
Lordship.
Section 40?
Lordship.
Which section you are referring?
40.
Yes.
43.
43.
Chapter 11, 40. Can I read them?
Yes, yes.
An appeal shall lie from a final order of the controller of the tribunal as the state decisions are made by law provided that until a tribunal is so empowered, an appeal from the final order of the controller shall lie in the high court. Now, Lordship, the tribunal is available. So far my order is concerned, this order. So can I? Lordship, my respect to submission, Lordship.
You have no respectful submission. When was the order passed?
Lordship.
When was the order passed?
Order passed on 2nd January 2020.
When this revision filed?
This revision filed on, Lordship.
7th April. Sir?
April.
7th April.
7th.
What is the time period for preferring an appeal under section 43 before the LRTT?
That will be 130 days.
You missed that?
No.
Now you have devised it to come before the court
Lordship,
to get a second life, so that if I dismiss your civil revision, holding that I do not have the jurisdiction, you will go before the
no,
tribunal.
Lordship, that is not point. Because of the.
That is the point.
Lordship, because of the, it is a final order. Because of the final order is.
Sir, the difficulty is that your application has been dismissed. Whether there are reasons, whether there are no reasons,
Lordship,
the dismissal amounts to the final order.
Lordship,
You could have taken all these points in appeal.
Lordship,
That look here, it does not disclose any reason. It is not a final order. What prevented you from taking?
Because
Sorry.
if it's the final order, that means I have to go to tribunal. Lordship is a final order because of my lord, can you allow me on 2 points, Lordship? And Lordship, so far, Lordship, our apex court is if this order in this, that is my
নিচে দেখি
Lordship, kindly. There is a 1961 Supreme Court, Lordship, on the second 795, Lordship.
Yes.
An order is a final if it amounts to a final decision relating to the rights of the parties, Lordship. That is when if the relating to the parties, I am the tenant, I have the right to deposit rent or not. That has not been discussed. Only the one line that has been time is not adhered. That has been lost.
The judge did a very incorrect, adopted an incorrect methodology, but the end result is that your application containing the prayers for allowing you to deposit has been dismissed. What can be the final order?
Lordship, that this is the final order in case of this drop. Case has been dropped. But the ground,
the difficulty is that you are trying to swim against the tide.
No, that is not.
Because what is final order? What are interlocutory orders with final trappings? If you look into the judgment of Shah Babulal Khimji, 81 Supreme Court, where to what extent letters patent appeals are allowed, there has been a complete discussion about it.
Lordship, in this point of this also been this citation has been also been considered. Consider. And
see, even if, let us say, I assume your submissions to be correct. Then also, this order has the trappings of finality in bringing your application to an end.
In Lordship, in respect of the
take down.
Lordship, can you 2 points? Sorry, 2 points. Can you give me, Lordship, that if it is final order, then I have to go tribunal. But this is not a final order on the aspect because of it is not been dealt with my right or what is the right. Why I am not debarred? Why I am debarred from my payment?
Sir, the difficulty is that you are trying to make out a case that the court did not provide for reasons why it has not allowed your application and why it has dismissed your application.
Lordship, that not been right. My right has not been discussed.
It's not required. It's not required.
Lordship,
It may be a bad order. It may be a wrong order.
Lordship,
But it has disposed of your application.
Lordship,
That is the finality.
No. So far, this order is concerned, Lordship. This order actually.
May I submit one thing?
Lordship.
He had only last order. There is a series of orders. That has not been done.
Lordship, if the order is if I have been gone for the preferred appeal before the appeal, Lordship, this comes to that one point, then this is not a final order. That's why, Lordship, this is the order, Lordship. Because
Because
Enough.
on the point.
See, if you continue till 4:30, I will not be
No,
convinced.
no, I'm not.
I will not be convinced.
But
Every matter has its own time and span.
Lord,
Sorry, I am unable to accept your
Lordship,
submission.
then give me a chance to go for.
Oh, that is what exactly I told you.
No, because of not that Lordship. In my impression, that is not final. My Lord is my Lord is correct. In this case,
I regularly repeat this physiology. Don't trigger my poison mind. I always try to leave it on that side.
No, Lordship. That part if I am the wrong, if I'm wrong, then Lordship can I go for this opportunity can be got because of I have the impression that this is not a final order. My Lord is correct. My Lord is correct. This is a final order.
Lordship, let me submit one. In the he has submitted the only by suppressing the fact that in previous occasion, in last occasion, honorable tribunal, learned tribunal, there is some observation of the honorable tribunal and was asked him to produce to satisfy on this timeline. And on that date, he did not submit anything, and that's why one line order. Previous order is there. That is a detailed order. That is suppressed in this.
That is not the penalty.
Take down.
Lordship.
Another Lordship, in this respect, what Lordship, another judgment is also there that Lordship knows of. That is Justice Prosenjit Mandal, that it is not maintainable on 21 orders.
Take down.
Based on Supreme Court judgment. They have to prefer appeal.
This part is to the final order, of course. That is the final order. In my case, this is not a final order.
Take down. This revisional application is filed by the tenant against an order dated 2nd January 2025, passed in H full stop R full stop C, all caps, case number 8/1 of 2022, dated 11 /01/2022, by which the application of the petitioner bracketed tenant under section 21 of the West Bengal Premises Tenancy Act 1997 was dismissed. It is well settled provision of law that against an order passed under section 21 of the 1997 Act, the aggrieved party has to approach the West Bengal Land and West Bengal Tenancy Tribunal, constituted under the West Bengal Land Reforms and Tenancy Tribunal Act 1997. In short, LRTT Act. Section 43 of the West Bengal Premises of the 1997. Oh, দুটোই তো 97 LRTT Act করে দাও। ওটাকে হচ্ছে ওয়েস্ট বেঙ্গল প্রেমিসেস টেনেন্সি অ্যাক্ট WPTA করে দাও। হ্যাঁ অ্যাক্ট clearly specifies that an aggrieved party is to approach the LRTT by filing an appeal. The opposite party, bracketed landlord, has also taken this point by citing a judgment delivered on citing a judgment of a coordinate bench of this court delivered on 24th July 2012 in CO number 3550 of 2005, bracketed Hemonto Bayabortha, BYABORTHA versus Sri Uttam Sasmal, SASMAL, Uttam UTTAM. In order to circumvent this hurdle, the petitioner says that an appeal under section 43 will lie under 43 of WPTA. Act আর করতে হবে WPTA এটাই হচ্ছে WPTA
in order to circumvent this hurdle, the petitioner says that an appeal under section 43 of the WPTA
can be filed only against a final order. The learned advocate for the petitioner places the order dated, places the order impugned, which reads as follow. We set out করে দাও, অল্প একটুখানি লেখা আছে, ঠিক আছে? এটা সার্টিফাইড কপি আছে তো আমি জাস্ট অল্প মার্কিং করলাম। Full stop. It is submitted on behalf of the petitioner that there has been no adjudication of the right of the tenant vis-a-vis the provisions of section 21 of the WPTA as to whether the tenant is entitled to deposit or is debarred from depositing the same. In absence of such finding, the order impugned cannot be construed to be a final order. If the same is not a final order according to the petitioner, the said order can be challenged by filing a revisional application. Responding to such submission made by the petitioner, the learned advocate for the opposite party submits that there are a series of orders which has led to the passing of the final order being the order impugned. The order dated, which is the order date?
Order dated 21/11/2024.
The order dated 21/11/2024 is placed, is placed before the court to demonstrate that the petitioner was directed to show evidence for payment of rent of October 2021 on the next date of hearing and submit evidence as to how the timeline as mandated under section 21 of WPTA was adhered to by the tenant, full stop. Section 21, 21, full stop. After hearing the parties and considering the materials on record, I find that section 21 of WPTA lays down the clear timeline regarding refusal to accept rent by a landlord on the same having been tendered by the tenant. If the landlord refuses to accept, then the tenant is required to send the same through postal money order. Within 15 days from such refusal. If the landlord fails to, now if the landlord refuses to accept the postal money order, which is delivered, which is returned back to the tenant as undelivered, then the tenant may deposit such rent with the controller within 15 days from the date on which it is so returned to the tenant.
That has been complied with by, because of only October, the rent receipt has not been.
What is that?
That has been evidence. Evidence that been given, but that is not been looked into. That is
On a conjoint reading of the order dated in November and the order impugned, it cannot be said that the order impugned is not a final order. In any event, the order impugned dismisses the application made by the tenant under the provisions of section 21 of the WPTA for deposit of rent. The dismissal of the application amounts to a final order. It may be a ground of the petitioner that there are no reasons given in the order, but that will not change the nature and character of the order to be a final order on the petitioner's apostrophe S application having been dismissed. The revisional application is the revisional application being such and such is therefore dismissed, however, without any order as to cost.
So my lord can given an opportunity to refer the that will.
Our arak round খেল।
No, my lord, not that is wrong. If my lord pleases to, that can I can. That if my lord can please, then I can take opportunity.
You have missed the, missed the time. A timeline of 30 days. Deep level.
I don't have the, I said the revisional application is not.
But
ওইখানে তার একটা দিয়ে দাও,
kindly-
কি বললাম, the revisional
We
application.
have been CO is therefore dismissed, however, without any order.
তার আগের সেন্টেন্সটা দাও।
My lord, he has the, if he want to prefer the, he can file with a condonation. That is available to him. In
No, I'm not giving him, no, sorry, I had understood. See, that is the difficulty with me. People have by this time understood that I do follow these things. I had also been on that side. Or quite a considerable.
No, considerable, and my lord is a brief. But this point, my lord, kindly give me that point. So that way, that can I be Can we go for my, exercise my right? So for my
You
life.
can, you
No, no,
can.
no.
Nobody
That- no,
objected.
No,
You can.
I am holding it's not maintainable. That's the
but-
reason I cannot grant you.
No, I can be given the liberty to go for,
No, no,
go to the.
no, no. You can
Go to the, that means.
You can go with section 5. There is no
No,
bar.
no.
Uh-huh.
That is.
There is no
Now,
bar.
this is again. In the aforesaid facts and circumstances, I find that this revisional application is not maintainable and is liable to and should be dismissed. তারপরে ওই
Item number 6. Item number 6.
Worship, item number 6, I am for the petition.
Yes. What is
If,
the matter about?
Matter is in respect of the order dated 6th of February 2025 in respect of the section 24 of the Hindu Marriage Act. I am being a husband. I am being aggrieved by this order, your lordship. The matter of the relevance of the fact is that this order has been obtained by the wife by supplying certain materials of fact which was legal. The wife under legal obligation has to show before the court, trial court, but he didn't perform her legal obligations as well. as-
What is the legal obligation according
Lordship,
to?
the matter, he has prayed for the maintenance, your lordship. The matter was been heard, but in respect of no asset declaration of asset was been called for, and already he has obtained one maintenance order under section 125 of the Maintenance Act.
No,
that has
that is not a bar. That is
No,
not
no,
a
no, no. I am not talking about the bar
See, you can assail the order
order.
if it is contrary to the provisions of the method laid down in Rajneesh versus Neha. Otherwise not.
Okay, I'm coming to that point also. My sole condition in respect of, I come before your lordship in respect of said order, that like minimum amount is to be made in respect of it. Like, in respect
What
of
do
the
you
act-
do? What do you do?
Lordship, I am a primary school teacher.
Primary school.
Teacher.
What is your salary?
Lordship, salary is 41,000. And
41,000.
Lordship, earlier, the learned court was pleased to show the salary slip.
No, I am not 41,000.
41,000, Lordship.
How much has the trial court ordered?
10,000 in section 24
Oh.
and 5,000 in 125. My respect full summation is, lordship, if your lordship kindly allow the minimum the amount, because two successive amount, lordship, I have to pay. And lordship, I have also stated in the fact that I have the loan amount. There are 4 members in my family.
You may have 100 loans. How does it matter?
Lordship,
The law is
as-
well settled that you have to keep your wife in a same befitting condition.
Lordship, same befitting concept.
Now you are getting 41,000. What are your other income? How much
No,
tuition?
Lordship, that-
How much tuition you do?
No,
Cash
no, no,
cash income.
that has to be made as far as the
Have you
land-
given any declaration? Have you given any declaration?
Lordship, Lordship, as
Sorry.
far as Lordship, made my summation. As far as the landmark judgment also, as Lordship very much well known. If there is I have no objection regarding the taking of the maintenance amount by way of the loss. But what it might need to be considered, the adjustment which the learned court has to be find out. They did not whisper about the fact that they has already obtained the order of maintenance in respect of the one.
Did you submit?
Lordship, it is the legal obligation upon the
Did
wife.
you? They have done a gross.
Lordship,
They have done a gross error. Did you submit? Did you take
was
this
not
point?
taken- that
Did-
was not taken into
then-
consideration. Lordship,
then-
kindly consider the amount.
Did you raise this objection?
That was been raised as per as instruction, but not been there in the
You
order.
filed your written objection.
I filed everything, your lord.
In the written objection, did you say this?
Lordship, there is a written objection. Kindly, Lordship, produce the page number.
I want you to say. Why should I peruse? You have come ready. You have not read.
No, Lordship, I have read, Lordship.
Then have you stated in that into 125 proceedings this has been awarded?
So although, Lordship, there has not been made, but My respectful submission is, Lordship, that minimum amount, I have no objection regarding the
Sorry.
order. I am paying also. Lordship, kindly consider.
15,000 is fair.
Lordship, 41,000, they are 4 members of the family loan. Lordship, I will pay also 12, 13,000, Lordship, Lordship allow. I will consider. I am paying also, Lordship. Lordship, kindly consider.
Have you paid that 5,000 and 10,000?
Lordship, they have made an enforcement execution. I have paying the same. I have not missed the single date, Lordship.
What about the areas?
Lordship, the areas that has been included, I am paying. I am on the 22 of April 25. I need to appear, Lordship. I have appeared. I have paid the amount.
See, whether you appear or you do not appear,
Lordship, I have appeared. I have paid.
it hardly matters. You have been directed to pay, you have to pay.
Lordship, I am paying, Lordship.
So pay 50,000. I
Lordship,
don't
kindly
find.
consider, Lordship, as minimum amount, Lordship, it will be, Lordship, because there are 4 members in the family. If I calculate also, Lordship, per head 15,000, it will not be.
Who are the 4 members?
Lordship, me, my father, and my stepmother and mother, Lordship.
Stepmother and mother.
Lordship.
Why your father is dependent on you?
Lordship, father is dependent on me, Lordship.
What did your father do?
Lordship, my father was a businessman, but now he is not working. Lordship, it totally solely depend upon me.
Sorry.
Lordship, solely depend upon
Sorry,
me.
take down.
Lordship, kindly consider, Lordship.
No.
Lordship, why if you
Yes.
minimum
He has
consideration.
not been paying any maintenance since 2020. It's transfer from the cross examination.
No, Lordship, the execution.
I have not provided.
Execution has been filed.
Kindly see the cross examination of.
I have not provided any.
I have not provided any maintenance to my wife since the year 2020. Only on the last occasion they filed only 3,000.
Lordship,
Their
that I
area
will
is
pay
around
because import.
This is an
execution has been made.
application.
I have
This
been
is an
appeared.
application
Lordship, I have appeared. Lordship.
by the husband assailing the order dated 6th February 2025, passed in an application under Section 24 of the Hindu Marriage Act 1955,
Lordship,
made by the opposite party wife.
It is, Lordship, the judgment which shows the adjustment now. Kindly, if your Lordship kindly consider, Lordship, kindly the paragraph, Lordship, which says, Lordship.
It appears from the said order that the petitioner is an that the petitioner bracketed wife. Now, কি বললাম? It
appears from the said order that the petition.
it appears from the said order that in the cross-examination, the petitioner bracketed husband has admitted that the opposite party bracketed wife is unemployed and the petitioners apostrophe s bracket husband's father-in-law has also died. In cross-examination, the petitioner has also admitted that he is an assistant teacher and his present salary is about 41,000 per month. The petitioner has also acknowledged in cross-examination that since 2020, he has not provided any maintenance to his wife, the opposite party. First, in this background, the Learned trial court. Has directed a sum of rupees 10,000 per month to be paid to the wife as maintenance pending. The order has also provided for a cost a sum of rupees 5,000 as litigation.
The order has also provided for, ওখানে বলেছেন a sum of 10,000 per month to be paid to the wife as maintenance pending. The order has also provided
For payment of rupees 5,000 to the opposite party wife as litigation cost. Full stop. The petitioner says that the amount, the petitioner says that under section 125 of the Code of Criminal Procedure 1973, in short CRPC, the petitioner has been directed to pay a sum of rupees 5,000 per month on account of maintenance to his wife. The learned trial court did not take into account this amount while directing payment of rupees 10,000 as maintenance pending. This fact, according to the petitioner, is contrary to the view, contrary to the ratio laid down. What is the citation? Rajesh versus Neha. Give me the judgment. In 2021 to SCC 324, Rajnesh 324, bracketed Rajnesh, RAJNESH versus Neha and others. Full stop. After considering the objection filed by the petitioner husband before the trial court, I do not find that this point has been taken by the husband before the trial court. In any event, rupees 15,000 is a reasonable and proper amount considering the facts of the case and the materials placed before the court. The husband, being a permanent assistant teacher in
Now
a school,
headmaster.
Huh?
Now he promoted to headmaster.
No, Lordship.
Okay, then
whatever may be,
Sir,
assistant teacher
125 was an ex parte order.
is receiving at least rupees 41,000. The wife, as appears from the record, is not supported by her father since he is no more. In such a situation, if the wife has to stay in an alternative accommodation and sustain herself for the month, a sum of a sum of rupees 15,000 is reasonable, fair, and appropriate. I do not find any infirmity in the order, even if it has not taken into consideration the maintenance amount directed to be paid by the petitioner, bracket husband, under the proceedings under the proceedings under section 125 of CRPC. This revisional application is devoid of merit and is as such dismissed. However, without any order as to cost.
So one individual is,
The petitioner shall pay the amounts as directed, including the arrears from the date of the, including the arrears as directed under the order impugned.
it's 10,000 as per as the 124 order. Lordship has stated 15,000. 10 plus 5. 5 plus, but in respect of my order, it's 10,000 which I have.
15,000 I have taken into account.
Lordship, joint 125 plus.
Yes.
Lordship,
Taken into account.
Lordship, what it,
ওটা
The petitioner shall pay the amount as directed including the area. As directed. The petitioner shall pay the amount as directed including the areas.
Areas.
না কি বললাম
Petitioner shall pay the amounts as directed.
including the areas shall pay all amounts including the areas as directed under the order impugned, dated so and so.
The date of the order shall put.
না ওইটা কেটে দাও এই পার্টটা কেটে দাও আমি পরে ঢুকিয়ে দেবো, ঠিক আছে? ওটা ছেপে রেখো আমি পরে ইয়ে করবো।
Lordship, one indulgence in the matter item number 9 that is fixed today, would be very grateful if your Lordship kindly fix it on Monday, as because the learned counsel Mr. Shamulda should be appearing in person in this matter.
Let it be there.
Very grateful, as your Lordship's convenience. Very grateful.
the statutory period ends tomorrow. Without the certified copy, I have the server copy attached with this petition.
Review against whose order?
Review against order passed by Justice Raja Kumar Mata in the
Rajshekhar Mantha and Justice Ajay Mukherjee. Go before the principal bench because see, even if I allow you to file it here, it has to go before the principal bench.
I have
Because no, you cannot file it because the review petition against orders passed by a bench, judges are available. So it has to go before the said bench. So you have to file it before the principal bench.
the period ends tomorrow. Today.
What can be done? What can be done? We are sitting from Monday. You did not come. You are coming on the last day.
Certified copy we have applied, but we still did not. get it.
Yes, you apply on virtual mode. You mentioned before Justice Mantha because see the leave has to be granted by. We don't have the jurisdiction also. The leave has to be granted by the said bench. Once you file it, the bench will be constituted because Justice Mantha and Justice Mukherjee may not be available before the circuit bench, even if they are in the High Court. May not be. Talk to you ask your counterpart in the principal court, talk to the registry of the Chief Justice, you go there. কি করে লিভ দেবো বলো তো? আমরা বলছি দেরি হয়ে যাবে। না না, আমাদের তো জুরিসডিকশনই নেই। ও ফাইল করবে ডিপার্টমেন্ট নিচ্ছে না, সার্টিফিকেট নেই বলে।
Item number 1, under admission of criminal appeal.
Milord, I am for the appellant. This is for admission against.
Who is for the state?
Milord, after admission of the court.
Criminal appeal automatically admitted. Admission, where is the scope? 302.
302, Milord.
কি হয়েছে? অ্যাকিউটেড এগেইনস্ট এসছে?
Conviction, against conviction.
Conviction, automatically. Where is the question of admission?
Admission হবে তারপরে court.
Has to be admitted first, thereafter.
No, you are not. You have not filed any application for suspension
No,
of
no,
sentence.
Milord, no, not it.
After the admission, the suspension.
Oh,
Further learned advocate appearing for the petitioner peruse the materials on the court, including the judgment of conviction and order of sentence. I shall let the appeal be heard. Appeal shall be heard. Appeal shall be heard. So,
Trial court record.
LCR, let the LCR now.
Trial court
PCR. Let the PCR be called for. An office is directed to prepare the requisite number of paper book. Petitioner has at liberty to mention this matter for investment after receipt of the, after completion of the paper. Completion and
After completion and receipt of the
receipt of the paper.
Problem is, Lordship, I am reading this matter. There are co-accused who have been convicted for 5 years. Now it is before the single judge's bench. So LCR, now it has to be the trial court record.
over there, LCR, the TCR has been called for.
The already order has been made. Now it has to be.
He has filed there before the single bench.
No, order has been made by the.
Before the division bench.
No, before the single bench, because co-accused 5
আরে
years only.
ও অ্যাকিউজ হচ্ছে 5 বছর হয়েছে, সেগুলো হচ্ছে সিঙ্গেল বেঞ্চে চলে গেছে।
Already called for there. Now the question will be, if this call for goes there.
Give the number.
CRA SB 8 of 20.
You give the number of the single bench, otherwise how will he record an order? Number and date. Don't worry, appeal has been filed, the
Single thing because 5 years money
Yes.
was there. But see,
less than 7 years.
but the principal accused life, so it's because the so
এটা
that's
কি
the problem.
কি দেখি অর্ডারটা কি হলো? এটা এইভাবে করো, হ্যাঁ ইয়ে পারতো এটাকে একটু রিকাস্ট করে দিই।
হ্যাঁ
This is an appeal by the principal accused who has been sentenced for life. Produce heard the learned advocate for the appellant and produce the materials on record. The appeal is required to be heard. We are told that one of the co-accused has
Three
been
co-accused. Other three co-accused.
no, appeal by one of the co-accused.
Before the single bench verdict, three co-accused.
Three appeals.
Four accused were there.
The 3 appeals have been filed.
No, one appeal by three co-accused.
আচ্ছা কি বললাম?
We are told that one of the two
We are told that apart from the apart from the appellant, there were 3 other co-accused. He said co-accused persons have been sentenced for 5 years imprisonment. The said 3 co-accused have filed an appeal before the learned single bench being such and such, wherein by an order dated, which order? Tenth
of this month.
By an order dated 10th June 2025, the trial court records have been the said appeal has been admitted for hearing and the trial court records have been directed to be trial court records have been directed to be sent to the circuit bench. In the aforesaid facts and circumstances, the registry shall prepare sufficient number of paper books and/or sufficient number of paper books on the arrival of the trial court record as directed directed by the order dated so and so, passed in so and so. তারপর হচ্ছে the appellant shall be at liberty to mention ওই যেটা ছিল আর
Is there one indulgence? There 20,000 rupees fine is there. Fine has to be suspended. Here.
Okay, you liberty is given, you file application.
লিবার্টি কিসের দিতে হবে? লিবার্টি এমনিও তো ফাইল, ও সাসপেনশন অফ সেন্টেন্সের জন্য তো ফাইল করবে, তখনই ওটা
Main problem is lordship. Before if going into the niceties, the 313 has been done mechanically when since some question no answers are there.
merits of the
During appeal you have to place full the facts. Even no answer, no blank, total blank. 4-5 questions. Answers are blank. Nothing.
ঠিক আছে, তো শুনে নিয়েছো তো অর্ডারটা যেটা রিকোয়েস্ট করো।
So that's a problem.
Okay, at the time of hearing. Adjust.
ও সাসপেনশন অফ সেন্টেন্স পরের সার্কিটে করো।
Item number 2,
I'm for the applicant lordship.
Defective, why defective?
Defective,
Belated?
yes, I have
Delay.
filed the plan application, section 5.
Oh. Can one and.
80 days delay.
Huh?
80 days delay.
Okay.
ক্রাইম টোটাল হবে
Ten years,
10 years.
sick also.
Also, I have filed another plan for suspension of sentence.
Item number 3 under landmark application.
My lord, I am for the respondent number 6, my lord.
I am for one of the respondents, the primary vote.
Who is for the petitioner?
My lord, the applicant of the last occasion did not appear. On 20th of May, it was taken up when they have not appeared.
Megnath.
উৎসব দত্ত
Megnath.
Devasthidhar.
Megnath.
Oh,
More appearing than
Devasthidhar is
disappearing.
there.
I gave the appropriate name.
Once, in the last to last circuit, that name was given to me. Your lordship was presiding in court number 2. Then subsequently, the title shifted to the Devasthidhar.
Nomenclature shifted. Because I find you more often before this bench. করে দাও এটা
Let it go
না,
before the
dis-
next circuit.
না why should we keep it? কালকে রাখো, না দাঁড়ালে ডিসমিস করে দেবো। ডবল স্টার দিয়ে রাখবে, ঠিক আছে? কদিন ডাক হলো, তাই ট্রিপল স্টার পড়ে যাবে।
That's a double star.
Item number 4 under order 41 rule 11.
এটা ডিসমিস, এটা ডবল স্টার আছে, দুদিন হলো, এটা মনে আছে পার্থভূমি।
Item number 4.
This is the third consecutive day when the appellant remains unrepresented. No adjournment is sought for. No one has applied to represent the appellant to virtual mode. The aforesaid facts and circumstances. The appeal. কি করবে এটাকে?
ডিসমিস, এইখানে বলছি ডিফেক্ট যদি না হয় shall stand dismiss.
আচ্ছা, না কি হয়েছে?
ডিফেক্ট সরিয়েছে।
Record record also reveals that the appeal record also reveals that the matter was adjourned on 25th September 2023 and 3rd September 2024.
ও বাবা, এটা ডিফেক্টও ক্লিয়ার করেনি তো। The court observed that the second appeal হবে বলে।
ডিফেক্টটা কি আছে দেখো তো।
কোর্ট অবজার্ভার রিপোর্টটা হচ্ছে সেকেন্ড appeal হবে, that certified copy of the judgment and degree of the trial court has been filed. Perusal of the names of the parties and valuation of the appeal are found to be correct. Name of the appeal, now all appeal is in form, instead appeal has been preferred against the judgment passed by the learned civil judge. Name has been allowed. Additional remanding the jail appeal. And that the appeal has been wrongly classified and instituted as FMET instead of ACT.
ও ছেলেরা ডিসমিস ফর ডিফল্ট করে দাও।
হ্যাঁ।
কেন মুশকিলটা কি জানো? একটা মানে বিচিত্র অভিজ্ঞতা হয়েছে আমার কয়েকদিন আগে। আমি ওই সুপ্রতিমের সঙ্গে ডিভিশন বেঞ্চে বসে 3 দিন করেছি, তোমার অ্যাডজার্ন করে, ও তো বেঞ্চ কনস্টিটিউট করতে হয়, করে ডিসমিস করলাম ফর ডিফল্ট। এরকম 3 দিন সময় দিয়ে নোটিশ দিতে বললাম রেসপন্ডেন্টকে। তারপরে রিকলিং অ্যাপ্লিকেশনে দেখা যাচ্ছে যেদিনকে ডিসমিস করেছি সেদিনকে লোকটা জেলে ছিল। ওই মামলাতেই হচ্ছে সিভিল প্রিজন হয়ে সে জেলে ছিল বল And কারুর তো বলার দরকার ছিল বলেই in the aforesaid facts and circumstances
ইয়েটা ওকে দেখবেন তো এ বলছে যে রিপোর্টার স্ট্যাম্প রিপোর্টারকে বলবেন তো এটা বলছে স্যাট হবে চ্যালেঞ্জ করেছে অর্ডার অফ রিমান্ড অ্যাপিলেট
ওর আগে দাও adjourn was adjourned to enable the appellant to
remove the defect
as pointed out in the report of the stamp reporter. It does not appear that the defect has been removed. তারপর in the aforesaid dismiss.
Five.
Item number 5.
My lord,
Concurrent finding by two courts.
concurrent finding that the plaintiffs, what the plaintiffs, they are not able to prove their tenancy right under section 2G of the Commercial Statute Act 1997. My lord, my substantial question of law, my lord, I have already placed before your lordship.
See.
Since the wife, the spouse of the original tenant.
What can be done? You have not amended the plan.
Can it be same for demand
No.
lodge? For the ends of justice lodge. For the ends of justice, kindly call.
When did the tenant die?
Madam, the tenant died on 20th March 2012.
So 5 years has already elapsed.
Lordship.
5 years has already elapsed.
But since the spouse is there.
Spouse is there.
The husband who is the
Spouse.
original
But
tenant.
see, you got the death of the original tenant recorded and substituted. In the substitution, you did not amend the plan.
Yeah.
Amend the plan and say that life interest is there.
The thing is, at the appellate court, my lord, one application, my lord, under order 41, rule 27, my lord, has been filed for, my lord, additional evidence of this spouse lordship. That has not been, my lord, considered. My lord, that application has been filed.
Who is for the
no
respondent? Who is for the respondent? No one appears.
It is not transmitted, it is order 41 lordship.
Oh, sorry.
My lord, the application under order 41 rule 27 filed on 27th February 2023. And my lord, that application has been dealt at the time of delivering of judgment lordship.
That does not make.
Delivering of the judgment lordship.
We often say.
The plaintiff did not get an opportunity to file a revisional application against the rejection order of this application under order 41 rule.
What was the application?
Application for additional evidence of the spouse lordship. Kindly consider lordship.
দেখো এটাও ভুল করেছে না স্পাউসের ইয়েটা একটা পয়েন্ট অফ ল এখানে
No, it's not. But the appellant, who is appellant before us?
Madam, the plaintiff,
She-
he is all along appellant.
Who is a
The tenant.
tenant?
Tenant. The original.
Surojit Das, Prosenjit Kumar Das, Sumit Kumar Das, and Deepali Das.
Deepali Das is the spouse of the original tenant, and those three are the sons of the original tenant. They have been substituted at the time of the trial launch.
পয়েন্ট অফ ল কি করবেন আপনি?
Whether
ব্যাপারটা হচ্ছে ও তো শুনুন 2012-তে মারা গেছে, ঠিক আছে, তখন প্লেনটা অ্যামেন্ড করলো। ও ফার্স্ট অ্যাপিলেতেও তো এই গ্রাউন্ডটা নিল না। ফার্স্ট অ্যাপিলে যদি এই গ্রাউন্ডটা নিত তাহলে হচ্ছে তাহলে তো ফার্স্ট অ্যাপিলেট কোর্ট ডিল করতো, তো সেই গ্রাউন্ডটা নেয়নি। এবারে আপনি আজকে পয়েন্ট অফ ল হার্শ হতে পারে, আপনি পাঠাবেন কি করে?
Page 49 of my stay application, this is the memo of appeal. There, my lord, in paragraph number 6, it has been stated, for that the learned trial court ought to have held that the defendants could not establish the fact that the wife of Ajit Das, the original tenant, occupy on any residential premises of her own.
Neither here nor there.
This much, lordship.
See, we told you on the last occasion, civil rights, they are not writ petitions.
Yes,
That
sir.
the court exercises their discretion.
Lordship can, your lordship. The lordship kindly send it for the remand at least, lordship, for at least, well, for the sake of justice, lordship.
See, the law is very well settled. In case ফার্স্ট অ্যাপেলেট কোর্টকে পাঠিয়েও তো লাভ নেই, কারণ কি ফার্স্ট অ্যাপেলেট কোর্টে তো এভিডেন্স নেওয়ার জায়গা নেই।
The trial court, lordship, for my lord, the addition evidence.
Has the decree been put into execution?
No, lordship, not yet.
who has drafted it?
এই সেকেন্ড অ্যাপিলে কোনো পয়েন্ট দিয়েছে দেখুন তো।
সেইটা দেখুন। Second appeal ground would be for that there is a substantial question of law.
না না,
Then the
এই সেকেন্ড অ্যাপিলে
question of-
সেকেন্ড আপনি পড়ছেন যখন দেখুন তো সেকেন্ড অ্যাপিলে এই পয়েন্টটা নিয়েছে।
Yes, that part has been taken out.
Where? So
ইস্যুস গুলো কি ফ্রেমড হয়েছিল দেখুন তো দেখি। উকিলের দোষে
Of my stay application. Or my lord, in memo of appeal, lordship page. The certified copy, running in my page 3.
inner page 3.
Yes, of the certified copy. My lord, bottom,
Yes, got it.
bottom.
Where is the, oh, yeah, judgment and degree of the trial court?
That it is, my lord, trial court's judgment and decree, lordship will get from the memo of appeal as also from the stay application. Memo of appeal, lordship.
A stay application, why you are saying stay application, where is the stay application? Only the memo has been given to us.
Lordship kindly comes to the, my lord, the inner page 3 of the certified copy. My lord, just starting from, last page from the pleading.
Oh,
এই তো issue, whether the suit is maintained, whether the suit is barred by any law.
now
that was-
relationship, whether issue number 4, what was the issue number 4?
আরে ওইখানেই তো গোলমালটা করেছে, ও ছেলেদেরকে ধরে দিল 2G নেই, 5
হ্যাঁ।
বছর হয়ে গেছে 2G রাইট নেই।
wife,
এবার তো ওয়াইফের তো আলাদা, স্পাউস হচ্ছে লাইফ।
সেইটাই wife
কি
কত
বলবো এখন, বলুন তো, পুরো একদম যেরকম উকিল বাবু সেরকম তার অ্যাডজুডিকেশন হয়েছে। বললে
the issue number 4 was
Rather the relation.
answered, how it was answered by the learned trial?
Issue number 4 is.
It was determined,
State that the.
there is a relationship.
The tenant in terms of section 2G of the West Bengal premises.
ও তো একটা ছেলে বলেছে আমি ওখানে থাকি না, আর দুটো প্রমাণ করতে পারে, দেখে নিয়েছি আগে।
Oh.
না, জিনিসটা অন্যায় হয়ে যাবে না ব্যাপারটা।
তাহলে appeal shall be had on the following, বলে আমাদের ফর্মুলেট করতে হবে, following substantial question of law বলে ফর্মুলেট করে দেবে।
কি রেখেটা লাভটা কি, আমি তো এটাই বুঝতে পারছি না। আমি অ্যাকচুয়ালি যেটা নিয়ে সত্যি হচ্ছে অসুবিধা হচ্ছে, যে ফার্স্ট অ্যাপেলেট কোর্টকে তো আমি ফেরত পাঠিয়ে লাভ নেই আমার। যদি এভিডেন্স নিতে হয়, ওকে লাইফ হচ্ছে ফর স্পাউস, ওকে তো দুটো কন্ডিশন ফুলফিল করতে হবে, দ্যাট শি স্টেড with her husband till the last date and she was dependent on him. এই দুটো তো কিছু এভিডেন্সই কেউ দেয়, প্লেন্টেও নেই, এভিডেন্সেও নেই। তো এবারে আপনি করবেনটা কি?
অ্যাপিল কোর্টে ফিরে অ্যাডিশনাল এভিডেন্স নিতে হবে, আমরা তো সুটে ফেরাতে পারি না, ফেরাবো
দিতে পারেন আপনি।
অ্যাপিল কোর্টে ফিরে অ্যাডিশনাল এভিডেন্স রিভাইভ করে দিলাম অর্ডার 4127, আমি যদি এখনই ডিসপোজ অফ করতে পারি, অর্ডার 4127টাকে রিভাইভ করিয়ে দিয়ে এবার অ্যাপিলে পাঠিয়ে দিলাম।
What additional evidence did you intend to rely upon?
My lord, the spouse lordship.
Where is that application?
Yes, my lord, that application is also there.
With
এই
you,
stay
not with us.
The stay application
Stay application বারবার দিয়েছি কিছু?
আদৌ ফাইল করেছে কি স্টে অ্যাপ্লিকেশন?
না, হ্যাঁ না, নো,
হ্যাঁ
রেকর্ডেড থাকবে ফাইল করে।
হ্যাঁ,
May I give my copy lordship?
you ascertain whether no, you ascertain where is the stay application, because if you have filed it, it should be on record. এটা খোঁজ করে দেখো তো, ইয়ের পরে নেবো, দুটোর পরে নেবো। We'll take it after 2 o'clock. Huh?
No stay application has been filed. And that is, what is the stay application? It would be injunction. You are in possession of the fruit property. So injunction, so that your possession is not disturbed.
কিছু দিয়ে তো লাভ নেই, কেন আপনার তো হচ্ছে 3 জন ছেলে প্রমাণ করতে পারেনি, এবার মাকে যেই দেবেন 3টে ছেলেও ঢুকে যাবে গিয়ে ওখানে। জ্ঞানাকলটা তো সেখানেই না, ও ইয়েতে ইনোসেন্ট ফেস করে এখন বলছে আমাকে ওটা ছেড়ে দাও, ও বুদ্ধি দিয়েছে, ওই হলে ছেলেগুলো ঢুকে যাবে সঙ্গে সঙ্গে।
No, my lord, it is, my lord.
তারপরে বলবে এগ্রিমেন্ট করো।
Now, if we accept and if we revive the application for additional evidence order for 2027, only one count that court required.
Lordship,
Other two counts are not available. No subsequent discovery, and you will not be proved that it was not within your knowledge
Yes.
at the time of giving evidence.
You try to get the stay application so that we can look into the applications.
Lordship.
Injunction, stay means injunction.
As per the learned, Lordship, kindly keep this matter tomorrow. If it is not filed, I am filing today only. So I'm not, I am giving this number so that it can be tagged.
কালকে দাও।
Sombar, Monday, I'm fine.
Monday, হ্যাঁ।
Lord, I'm grateful, Lord.
কারণ ওই দুটো কাউন্ট ওর জন্য অ্যাভেলেবেল হবে না। যে at the time of giving evidence, it was within his knowledge, his or her knowledge. Now it is not subsequent discovery. Now only the court requires.
ওই জিনিসটা ঘেঁটে দিয়ে রেখে দিয়েছে।
Yes, very. Yes. 2 times taken.
Who is for the respondent?
We don't have to admission.
What is the substantial question of law according to you? Yes, what is the suit about? Yes, of?
License.
Very well, very well.
They are affiliated, they defended. And-
Yes, you are the tenant or the, then?
Mother,
Oh, yesterday you said, yes.
sir, admitted and brought up saying that, I will book the license. The hybrid school and the current trial court dismissed this school that there is no cause of action. There is no more mode of evaluation. There is no notice was served. The trial court finding. The appellate court no notice not required. And instant filing of the court but we of the all of action I think appellate court finding mother. 1980 he was in the year 1980 present appellant adopted by him.
Adopted. The husband of the was alive then.
Certificate.
How was the adoption? How did the adoption?
At that time, only oral evidence that there is no there is no
Document.
at that time, year 98. Late also, being brought up and her name and her husband name also used.
What is the age of your client? Independent. Why do you want to stay over there?
Family,
Family man.
also daughter is also foreign regarding property, for this reason,
That's the reason I asked you.
4 person,
No.
4 person. Kind of same,
Let us see first the judgment impugned.
Your only question of law that no notice was served. Your licensee or permissive possessor.
Adopted.
No. Your status in respect of the property in question, property in question. You are mere licensee. It is well settled. This property is held by the father, son would be permissive possessor. And every year. So you are permissive possessor. So you show any that here notice is required. Show any judgment and authority that notice is required. Because license can be revoked expressly and impliedly. Whether the filing of the suit itself is a notice or not. Filing of the suit itself is a notice. Yeah, it's better we are alive to the issue.
Yes. Yes. Tell me, which is the judgment you are referring to? Easement Act. Justice Ganguly's single bench, Justice Bhattacharya's division, Bhaskar Bhattacharya. Easement Act does not have application in West Bengal, but the provisions analogous
Principle.
Well,
So say
না না ওটা দেখিয়েছে তো জাজমেন্ট আছে দেখো না ভেতরে দিয়েছে ডিভিশন বেঞ্চ আছে যেখানে নো নোটিস ইজ রিকোয়ার্ড নো অ্যাপিলেট করে দেখো ইয়েতে তো ইন্টারনাল পেজ 8 ওখানে দেখো ক্যালকাটা একটা ইয়ে করেছে কনসিডার করেছে যেখানে বলেছে
we have to admit, we have to formulate the question of law. You say that what would be the question of law, substantial question of law. Not all question of law, substantial question of law. So say, you formulate the question of law. That on this question of law, this second appeal should be admitted.
It's not required. বেনামি প্রহিবিশনও ঢুকিয়েছে বাবা কত আর্গুমেন্ট পড়েছে
Appellate forum, it was the proper, my adopted father, adopted father purchased Benami property.
বউয়ের নামে প্রপার্টি যদি গেলে কবে বেনামি হলো এই আন্ডারে কি বউ আর ইয়েতে মেয়ের নামে মুশকিল বলো তো
Husband cannot purchase the property in name of his wife. That would be Benami. Son is to stay at the house of parents with their consent, and best relation is the rent. Respect is the rent, license fee. Yeah. The peasant's second appeal has been.
Yes.
Yes,
Yes,
placed in the list for
yes.
admission.
What judgment? Yes. They only.
Yesterday I also found that if any authority was found or not, even calamity pardon also. I'm not.
See, yesterday you took time.
Yes, ma'am. Yes, ma'am.
Today also you are asking for time. Monday you will ask for time. And in this manner, you will complete the entire circuit up to Friday. Why part? What interest? Tell me one thing. Tell me one thing. What is your case? The admitted case is that the that the plaintiff who had filed this suit, the mother, she along with her husband used to stay in a different place beside the river. Now a little boy was found abandoned in the river bank. A cowboy brought it to the family. They, out of sympathy and love, took care, imparted you education, gave you life, allowed them to use their parentage. Now, after initial stay, she had come to a particular purchased a particular plot and built a house over there. In that house, you had been allowed to stay. Now, the allegation is that even you have got married, you have 2 children. The allegation is that you are misbehaving, and as a consequence hereof, you were asked to go away. Now, what is the wrong in this? Now you are trying to bring in notice. You are a rank trespasser. No, nothing doing. We don't go by sympathy. No sympathy.
What interest of that?
What interest of it? There is already a judgment. You said, see, I took the pain of going through the entire judgment. Now 2004 division bench judgment, which has clearly held, which has clearly held that no written document is required revoking the license. Now 2020 Supreme Court judgment has been considered, which was also considered by that there is no valid adoption document. even if we go assume without admitting that it was a proper adoption, then also she is entitled to use an enjoyment of her property. She does not want you there. Where is the ground? You are trying to spin out stories. What one day? No. Tell me, what will you do?
I'm not leading. I'm not saying the next circuit or anything. I'm not nothing. Yes, I also one day. One day.
What? Tell us what will you improve?
I will try my level.
No. What level based? কালকে একজন করলো পড়ে এলো না, আজকেও বলছে পড়বে। এত লেখাপড়া করলে তো মক্কেল পয়সা দেবে না। Why? You did not get the material instruction? You are apprehending if the second appeal is not admitted, the material instruction will not come. আর কি হবে? সবই তো হচ্ছে আজ নয় কাল, কাল নয় পরশু চলছে। Please reserve your energy for a arguable case. Don't flog a dead horse.
Item number 7.
Lordship, come to the petitioner, Lordship. Lordship, last occasion directed to serve the copy. I have served the copy, but service not effected, Lordship.
Why?
Lordship,
Before admission,
no, matter was admitted.
Thereafter, they are admitted.
Okay.
Presented defective. তারপরে হচ্ছে order. Remove the defect.
Order 9, Rule 13, rejection.
Yes, yes, Lordship.
Yes.
Lordship, last occasion directed to serve the copy and serve the copy, but service not effected, Lordship.
Serve the copy means what? Serve the copy. Where is the defendant? Who are you? In the suit? In the suit, who are you?
In this mat suit, I am the defendant. I am the defendant.
You are the defendant. Now, you are the defendant husband.
No, my lord, wife.
What?
Wife.
Why?
Wife.
Oh, you are appealing.
My lord, if I may be permitted, my lord, I guess that the report that we received back from the postal departments, the door was found locked.
So who was the advocate in the trial court?
My lord, I was just angling to suggest that if my lord is kind enough to direct us to serve on the advocate on the trial court, we will serve on the advocate. But we need a direction from the honorable bench. I know Mr. Kunal Bosak was the plaintiff advocate. Both are of them from Darjeeling.
Where is your affidavit of service? Only one copy. You are before a division bench.
Second copy is ready, but it's present status is only.
See, I deprecate this practice.
Mr. Dotto, where is the second copy? My lord, I beg to be excused for my junior's fault.
Now, what is your count? Summons not served.
No, my lord, the advocate who was in charge of the case met with an accident and he had a severe accident. He had got steel implants in his leg.
So there is a sufficient cause for non-appearance.
Lordship.
On the date, the matter was called on.
My lord, that apart, my lord will find several infirmities. Like when the learned judge has held we had appeared and filed the application. Actually, it was before that. My lord, that needs to be explained, but we are not being able to serve.
Affidavit of service filed in court today is taken on record. Give you a second copy.
Not stated.
It's taken on record. It's taken on record on a perusal of the effect on a perusal of the affidavit of service. It appears from the postal track report that the door of the premises where the article was attempted to be delivered on the respondent was found locked, and as such the service could not be effected. The aforesaid facts and circumstances, particularly keeping in mind that the appeal arises out of a matrimonial suit, and the respondent is the wife of the appellant, the appellant is directed to serve the learned advocate for the respondent who conducted the case before the trial court.
Obliged, my lord.
Let this matter appear on Mongolbar দিয়ে দাও।
Grateful, my lord. With your lordship's kind leave.
আরে টিটা থাকতো। ও আচ্ছা।
অর্ডার নেই তো কোথাও।
কোথাও অর্ডার আমরা খুঁজে পেলাম না। লেট দি ম্যাটার অ্যাডমিটেড। হয়তো কোনো বেঞ্চ বলেছে অ্যাডমিট হয়েছে এরকম কিছু খুঁজে পাওয়া যাচ্ছে। তার আগেই কেন সব একটু বলবি। এটা
আচ্ছা কি বলি, কপি অফ দি অ্যাপিল অ্যান্ড দি অ্যাপ্লিকেশন করে দাও, ঠিক আছে? Copy of the memorandum of appeal and the
application. Have you filed any application? আছে? Any can? No.
আচ্ছা ওখানে দিয়ে দেবে।
In item number 8, I am appearing for the appellant.
Informing the that this matter will be taken up on or
My lords, in item number 8, I am appearing for the appellant.
Yes.
Yes, my lord, there was a direction, your lordships have directed us to file the, to submit the deficit court fees. Well, we have submitted it on the 23rd day of May, as per your lordship's direction. And this is a first appeal arising out of the judgment and order dated 30th March 2023, passed in title suit number 86 of 2019 by the learned civil judge senior division at Siliguri. This was a suit.
Lordship, prior going to the merit of this case, Your Lordship, the appeal has been preferred on 26th of September 2024, and since then, no Section 5 application has been preferred by the appellate, Your Lordship. And on the last occasion, Wyden ordered it 21st May 2025 of the coordinate bench, they had paid the deficit court fees. Kindly consider the conduct of the appellant, Your Lordship.
No.
My lord, it's not barred by limitation. May I explain, my lord?
Our stamp reporter did not indicated that it is out of time.
My lord, the time which was required, my lord, if I may submit, the time which was required for the obtaining the certified copy has to be taken out from the computation, my lord.
4th of April 2023, you applied for.
Yes, my lord.
21st of June, you
2024. It took
yes,
2nd of my lord, July 2024. The copy was received.
see that day, that time will not be included because
Yes, my lord.
21st of June, 21st June, you have been intimated. If you do not collect it, then it is your difficulty.
The appeal was preferred on 26th of September 2024, Your Lordship.
24?
Yes, Your Lordship.
তো ইয়ে তো হয়েছে সেইখানেই তো এই দেখুন না
এই কেন এখানে রিপোর্ট দিচ্ছে না কেন যে এটা দিলে কোনো রিপোর্ট নেই রে।
এই যে আপনি সার্টিফিকেট কপির পেছনটা দেখুন ফার্স্ট পাতা
আমাকে দিয়ে দিন এটা
নিশ্চয়ই থাকা উচিত দেখুন
হ্যাঁ 7/4/2003 2/7 the copy was ready for delivery 21/6 না রিকুইজিট হচ্ছে 21/6 2/7/2024
Yes, my lord. 2nd July 2024.
Okay, from the limitation starts from 2nd July. You filed on
26th September 2024.
whether it is not within the period of limitation.
Then,
Huh?
then it
90 days.
90 days. It has
So
not.
90 days. It is not 90 days.
No.
Appearing to 2 months.
Yes. Then,
Huh?
then it is because I calculated from the date of
May,
decree, Your Lordship.
date of degree, what is the date of degree?
30th March 2023, Your Lordship.
30th March ও অ্যাপ্লাই করলো কবে 4th April
4th April.
তার মানে ওখান থেকে হচ্ছে 30th March থেকে
4 days, my lord.
4 days
Okay, 4 days. 4 days, then 2nd June, 2nd July to 26 September. How many days?
It was within 90 days, my lord. If 4 days is taken from the date of filing, my lord.
Yes. It would be within 90 days.
Yes, my lord.
Our stamp reporter, Learned Counsel generally did not commit mistake in
Yes,
counting the date also.
Yes, Your Lordship, but
Ah.
I presumed it.
No report has been placed before us that it is a belated approach or
Lordship.
barred by limitation or nothing.
Lordship.
but the thing is that we are not getting any order admitting the appeal.
No, it is for admission, my lords. It is for admission.
Admitted.
First appeal is for admission.
Yes. What is the ground?
My lord, kindly appreciate, my lord. My lord, the respondent defendant is the owner of a 4-storied building.
Yes.
Wherein, my lord, the appellant plaintiff is a tenant having tenanted premises of 950 square feet. My lord, the building consists of 4-story in total 16,544 square feet. Out of which 950 is tenanted to the appellant.
Just a minute.
Now, my lord.
Just a minute.
Oblige, my lord.
Yes, what are the infirmities you say in the judgment?
My lords, presumably, my lord, rest of the building, that is 15,594 square feet, approximately, was was in the possession of the respondent plaintiff. Now, my lord, the respondent plaintiff did not adduce any evidence or led any evidence to show that the Schedule A property, that is 15,594 square feet approximately, is insufficient to cater his requirements. The learned trial court also did not find any, returned any finding that the possession of the A schedule property, 15,594 square feet, which remained with the respondent plaintiff, is insufficient to cater his needs. Kindly appreciate, my lord. I am a tenant in the ground floor. I am occupying 950 square feet. The entire building is a four-storied building, which is in the occupation of the respondent plaintiff. The total building area is 16,500 odd square feet, out of which 15,500 odd square feet is within the possession, was always within the possession of the respondent plaintiff. Now, my lord, in my humble submission, my lord, the respondent plaintiff was required to lead evidence that to cater his requirement, my lord, the dispute cropped up in this. I am running a pathological lab in the 950 square feet. Now, plaintiff brought the action and saying that he also requires to install a pathological lab as well as a X-ray and USG machine, which is why he requires my premises, which is in my tenanted possession. Now, my lord, kindly appreciate, my lord, the learned trial court did not return any finding that for installation of a separate pathological lab, the 15,500 and odd square feet, which was always within with the possession of the respondent plaintiff, was insufficient. Even the plaintiff did not let any evidence to that effect.
Who is the best judge to decide?
My lords?
Who is the best judge to decide it?
My lord, in my respectful submission, my lord, there has to be pleading in that effect, and there the plaintiff was required to lead evidence that the building which is in his possession, that is the A schedule premises, is insufficient to cater his requirements. Lordship, may kindly be pleased to call for the lower court record, my lord.
দেখুন ওটা তো ইয়ে
চলে যাবে মাসের মধ্যেই
Yes, what do you say?
Triggered, your lordship. On earlier occasion, the premises when the plaintiff took, there was no reasonable requirement, but subsequently it was needed because he is running a nursing home, your lordship, and for that he needs to have USG facilities and X-ray machines and pathological. So for that he has to take his clients, the patients, your lordship, to another place for all those tests and all those X-rays, your lordship. So this is a basic need, and the reasonableness has already been proven, and there was a board of directors meeting that had been already the witnessed in the depositions. It would show, your lordship, that there was a resolution that they require all those upgradation of their nursing home, your lordship, and that has already been taken care of, your lordship, and it has been reflected in the order itself, your lordship. And moreover, your lordship, that in this regard, your lordship, the petitioner had given notice within time, your lordship, and the appellant here, in your lordship, they did not vacate it. So the order has already been passed and execution petition has already been filed, your lordship. That is execution case number 5 of 2025, your lordship.
বুঝলো? বুঝলো? This appeal has been filed, asserting the judgment and decree dated
30th March 2023. Your Lordship.
Decree was drawn on 18th April 2023. Judgment dated 30th March 2023. Decree was drawn.
Date of judgment and degree would be same.
My
Order,
lord, in this case, my lord.
order 20 rule 7.
Yes, my lord.
Read order 20 rule 7. Oh.
what is dated 30th March 2023, passed in title suit number 86 of 2019. Passed by the learned passed by the learned civil judge senior division Siliguri in title suit number 86. The respondent had filed the suit for eviction of the defendant oblique the respondent oblique plaintiff filed the said suit for eviction entirely on the ground of reasonable requirement. The case of the plaintiff respondent is that it operates a nursing home from the premises in question, a portion whereof is the suit property. The respondent appellant has contended that the space under occupation of the appellant defendant is necessary for setting up necessary diagnostic equipments for effective and better functioning of the nursing home. In absence of sufficient space, the plaintiff respondent has to take the patients to outside premises for availing the diagnostic facilities. The defendant resisted the prayer for eviction on the ground that mainly on the ground that the space already available to the plaintiff, to the respondent plaintiff in the building is sufficient for carrying out the nursing home activities, and the portion under the defendant is not required by the respondent. After considering the material evidence and the applicable law, the learned civil judge senior division, the learned court, learned trial court has passed the decree for eviction of the defendant. the it is also the case of the respondent plaintiff that they have already put the decree into execution. Put the decree into execution by filing an execution case being EC5. What?
Lordship,
EC
2005 of 2025.
before the court of the civil judge senior division.
Lordship.
So you have to-
The T execution case.
T execution.
TEX case.
Yes, sir. After hearing the parties and considering the materials on record, we do not find any infirmity in the judgment and decree assailed in this appeal. We also do not find any cogent ground for admitting the appeal. আর কিছু বলবো? হ্যাঁ, বলে দিলে ভালো হতো। আচ্ছা।
And the plaintiff has, plaintiff by adducing convincing and reliable evidence has proved that he reasonably required the suit property. Stop. As noticed previously, the plaintiffs running operating a nursing home from the premises without any facility available for facility at a nursing home and without any pathological lab, X-ray machine and USG machine and proper incentive care unit. Stop. Principal have admittedly this facility is essential to attend the serious patient, and for not having such facility in the nursing home, it was outsourcing such service from the other service provider or from the other laboratories located in the area,
Laboratories oblique diagnostic center.
and diagnostic center from the area. So, thereafter, on close scrutiny of the evidence brought on record by the parties,
we do not find any cogent ground.
We do not find any cogent ground, and we do not find any infirmity and perversity in the judgment and degree impugned in this appeal, and accordingly the appeal being devoid of merit is thus dismissed. No order.
Much obliged. Much obliged.
Item number 9.
মাসিমাকে সম্ভবত এক ডাক্তারি পাবো যারা অ্যাকচুয়ালি হাইকোর্টে প্র্যাকটিস করে। ও কি নাম দেখলাম শিলিগুড়ি নার্সিং হোম। ও
My lord, I'm for the appellant. My lord, I've
Yes.
filed an application seeking for pendency like maintenance, my lord. I'm the wife who was.
Section 24 application.
My lord, this is 36 Special Marriage Act application.
Oh,
My lord, my ground for challenge in the first appeal was that the trial court has wrongly allowed the application under Hindu Marriage Act. And since section 2, subsection 2 of Hindu
who
Marriage
are
Act.
you? You're the husband.
Wife. I am a tribal. I am a scheduled tribe member. So, my lord, by the section 2, subsection 2, my lord, Hindu Marriage Act is not applicable in case of tribal. My lord, so in this case, my lord, the court below has passed an order of decree of divorce under Hindu Marriage Act, my lord, which is not permissible under law.
So why don't you go for a review? Why did you come in appeal? Tell us, it is if it is an error, it is error apparent on the face of record. What you submit. Then why didn't you go for a review? You contested the first appeal. You contested the. You are now coming
This
up.
is the first appeal.
You contested over there.
My lord, the suit was not, my lord, to be honest, my lord, this matter was taken up by pro bono by the legal aid cell, my lord. The wife was not represented properly before the learned trial court.
I don't know,
There were certain discrepancies, it was not conducted, and these points were not raised also, my lord. That was the main concern.
Suit was filed under section 13
My lord,
Hindu Marriage Act
yes, by the husband.
by the husband. At this point has never been raised before.
That was not raised, my lord. This is.
Yes.
But my lord, this is not a, this is a subject matter dispute, my lord.
Yes,
It is not
what do
a
you say?
dispute of territory.
Madam, on behalf of the husband, my lord, Mr. Pankaj Bora from Guwahati High Court Civil Appellate Bhande.
Pankaj?
Bora.
Yes.
My lord, kindly fix on Bhande.
My lord, I'm just seeking, my lord, maintenance, my lord, because paper books are being prepared, my lord. I will serve upon the parties. We have received notice recently, my lord.
Very well. Why Monday? Why not tomorrow? Why is it difficult?
They want to come physically.
Physically. Everybody wants to come to us.
Physically, my lord, but today first time, my lord, they mentioned, my
The
lord,
bench is so watchable that everybody has to come physically. Why?
kindly fix on Bhande.
তো কেউ করবে না বুঝেছো তো রেখে দাও সোমবার
My
মঙ্গলবার
lord, the wife is suffering, my lord, because no alimony was granted. She is not having a
just remind
way
us.
to maintain herself, my lord.
You just remind us.
Because she was receiving alimony under 24 under section.
My lord, there was a, she was receiving to 10,000.
During pendency of the suit.
Yes, ma'am. All the while she was receiving, even after the filing of appeal, she was receiving. Last 3 months, my lord, she has not received.
What does the husband
Now his
do?
husband is in army, my lord. He is in a good post, your honor. He is drawing salary more than 60,000 rupees.
If you are scheduled caste woman, atrocities have committed against you. Why didn't you write to the defense authorities? You do not know.
I was not there in conducting the trial
There
there.
is a specific rule.
When I got to the records, my lord, it was very, it was not conducted properly, my lord. That is, I don't want to assert anything upon the conducting counsel.
Kindly make it Bhande. I will
সোমবার
take
করো।
instruction.
After Rohit Sharma's departure, India team requires an opener. So you have become the opener in the Jalpaiguri circuit bench to seek adjournments. Opening ball,
Adjourn.
Item number 10. Item number 10.
কতবার দেখা হলো? হ্যাঁ, তাহলে যেগুলো দুবার করে হচ্ছে কালকে ডবল অ্যাস্টেরিক্স দিয়ে রাখবে।
Item 11.
Lord, I am for the appellant. Lord, this is a first appeal, my Lord, challenging the decree of nullity of annulment of marriage granted by the learned trial court. My Lord, I am the wife. Lord, I have filed this appeal, my Lord, along with the stay application. But service is complete, but they are appearing.
Special Marriage Act or Hindu Marriage Act?
Hindu marriage.
What is the ground?
My Lord, ground is
Non-consummation or?
non-consummation.
My Lord, I appear on behalf of the respondent, my Lord. I beg to appear to virtually mode. Condition is
Not
impotent.
consummated due to
Yes, Lordship.
That is
Lordship.
their case.
fault on the part
That
of
is,
the husband.
yes, that is their case. Now, my Lord,
Oh,
in page 7, internal page 7 of the judgment, my Lord, the learned trial court has relied upon certain, my Lord, documents exhibited by the husband, and my Lord came to a prima facie finding that the lady, my client, is important. Yes. And as such, my Lord, granted the decree saying the marriage is annulled. Now, my Lord, there are two things on which, my Lord, I have harped upon. The first thing is, my Lord, my defense witness, who is a doctor, my Lord, she has not been examined. She was although summoned, but, my Lord, without any application of mine. My Lord, that order of summoning, my Lord, has been recalled by the learned trial court, and the expert who was supposed to be testify in my favor, my Lord, has not been examined by the court. My Lord, a private doctor called by my husband, my Lord, has been examined, and on the basis of that evidence only, my Lord, the order has been, the judgment and decree has been passed. My Lord, this is one aspect. Second aspect is, my Lord, the issues gone into by the learned trial court is very complex medical issues, which requires to be tested on the basis of, my Lord, experts' evidence and not derived by any private parties.
Mr. Chaudhary,
Lordship.
Dr. Chaudhary.
My Lord.
Now, expert evidence under section 45 of the
Indian
Evidence Act is necessary where the court is of the view that complicated issues require experts' view for better understanding.
My Lord.
If the court has formed an opinion that I do not require the expert evidence, can you point out any fault in that?
Lord, I cannot.
I do not require.
I bow down before your lordship. What is falling from your lordship is absolutely correct. If the issue before the learned trial court is something which can be adjudicated by any person or any judge, my lord, then it is a different issue otherwise. But the issue before the learned trial court is a complex medical issue, my lord. Neither the advocates.
That is complex medical issue to you. It may not be a complex medical issue.
My lord, may kindly see then the reasoning of the learned trial court. Kindly come to, my lord.
No, whether one MRI report was produced.
Yes.
Whether any doctor was.
One doctor, one private doctor was also testified, my lord, on behalf of my husband. On behalf of my husband. But
you cross-examine, you got a.
I have cross-examined. I have cross-examined.
না ওর তো নিজের সাক্ষী আনার কথা ছিল ও সামান করবার জন্য দরকারটা কি Trinity make an application he could have gotten expert opinion and he could have adduced it in evidence.
No, kindly
it was summoned. Lordship, separate doctor has
been
summoned.
I have not completed
by the
appellant. You will have your chance.
He didn't turn up.
This is very.
No, see, let us take it in this manner.
Lordship.
The court committed wrong. Court ought to have summoned, did not summon.
Lordship.
But in a suit, in a civil suit,
Lordship,
you have to adduce evidence.
My lord.
Did you get any expert opinion and had placed it before the court? Did through any expert, it was open to you.
No, no, but I have placed documents to that effect, and that document has to be proved by the concerned person. My lord. Well,
Suppose you are the, let us take this, the defendant's witness action is going on. You can, if say the incident had taken place in a government hospital where she has been, say, examined or medically tested,
Lordship.
you could summon the government doctor.
Lordship.
An alternative mechanism is also available. You could have got her examined through a doctor, say a gynecologist with appropriate equipments and qualification. And you could have tendered that opinion through the said doctor as part of your evidence. Did you make any endeavor?
Lord, I am the wife. I have tried that. I am the wife, my lord. I have placed documents before the learned trial court saying that the allegations against me are incorrect. And my lord, what they have brought on record is a private doctor's, my lord.
Well, let us not go by that. What you have done.
Lord, I have brought documents on record, Lord.
See, today, the plaintiff's evidence is over. Thereafter, the defendant is called upon to add his evidence.
Yes.
Now, you had produced certain documents.
Lordship.
The documents, which were produced,
Lordship.
is say medical reports.
Lordship.
Now, these medical reports has to be corroborated.
Minor.
Now, when you produce this document,
Lordship.
the plaintiff, the husband plaintiff,
Lordship,
did not put any question on that. Naturally, it's your document. Why should I examine the witness on that and get your document as exhibited through my witness? Fair enough, no difficulty. Now, when this was not done, it was open to you. You ought to have brought an expert evidence, getting you the wife being examined medically through a doctor, maybe
I have
government
prayed
doctor.
before the court. I have prayed before the court.
Not necessary.
Lord, paragraph page number 40.
The court did not find it.
Lord, we then kindly come to the reasoning of the learned trial court once. Lord, what the learned trial court has decided, not kindly see once.
Marriage was solemnized on 8 February 2022, 2012.
2012, yes.
Thereafter, the wife was taken to a doctor with a complaint of stopping of menstruation such and such in October 2013.
Yes.
Before that, there was no such complaint.
No, nothing. Milord, 1 year, the statute says, Milord, the period of limitation is 1 year. When a person is alleging non-consummation of marriage or nullity, Milord, that aspect.
See, all these are there. If you have chopped your leg, who is going to? You have conducted your case to your detriment. Who is going to rescue you? You are already into the ditch. Who will lend you the hand to pick you up?
My lord, I have prayed before the learned trial court. Now, my lord, kindly see the reason.
It's not necessary. It is not necessary. Why will you pray? Suppose I prayed for, suppose you pray before me for appointment of an expert. I feel that no expert is not required. Is your evidence shut? The next thing, this is where we lack. We lack in conducting a trial. Most of the advocates who take up the burden of trial, they do not either apply their mind or they do not actually do justice to their name and to their client.
Well, there has to be a way out. Now what, my lord, what is falling from your lordships, my lord, that if the judge is of the view that the opinion, expert opinion is not required, then my lord, in that event, my lord, what is the remedy before me? Because this is the
Yeah,
complex question.
the remedy was that you should have ordered examine and you should have brought an expert to counter it.
My lord, that is what I was doing.
You had asked for the court
My
to
lord,
do.
the doctor said that she will not come unless she receives an order from the court. My lord, I cannot force somebody who is a practicing doctor, my lord, to come unless she is receiving the court summons.
Then
Lordship, may I?
then the difficult, please. Then someone was issued.
Lordship.
She did not turn.
Yes.
Now, in such a case, you are doing criminal cases. What happens?
No,
Go ahead,
order 16 rule 12 is there. You can enforce.
Not bailable warrant was also issued. Issued.
Bailable warrant, non-bailable warrant.
Issued.
You come to order 16 rule 12. Don't think that our legislature has not addressed
No,
it.
my lord, bailable warrant was issued.
Yeah,
And
thereafter non-bailable warrant.
Subsequently, it was recalled. Subsequently, it was recalled by the court concerned. The court says that her presence is not mandatory, not required.
Did you come at that stage? Why did you to challenge that recalling order?
No, I did not do that.
Several opportunity
I
was
did
given.
not do that. Milord, this is a first appeal. The court of
No, fast. Let us go by the legal provisions. First
Lordship.
appeal, second appeal.
Lordship,
Second,
may I submit?
see,
Order 16 rule 10, 11, 12, you go on. You 10, 12.
তারপরে ওকে তো ওই জন্যই বললাম হি ডাজ দি ক্রিমিনাল কেসেস আজকে যদি হচ্ছে ইয়ে সাক্ষীকে ইয়ে পাঠায় সমন পাঠায় না আসে অ্যারেস্ট হবে না না ও তো ভুল করেছে আমার দেখা হয়ে গেছে ও এমআরআই
Doctor came and doctor gave the evidence.
Not curable at all.
যাও ও তো এটা ও ডাক্তার যখন এলো তখন তো হচ্ছে ও আর একটা ডাক্তার এগেইনস্টে করাতে ইয়েস ইয়েস
Yes, Lordship.
Yes, what do you say?
Yes, Lordship, the evidence of the doctor and evidence of the person who tested the MRI has not been annexed with the stay petition. I have I have obtained a certified copy of the evidence. I can show one line, Lordship. My colleague sister is there to hand over the
not hearing the appeal,
certified copy.
final
Certified
stage.
copy.
I'm not here. We are not hearing the appeal. We are not hearing the appeal.
One
We are
line,
at the
one
admission
line.
stage.
Yes.
Yes.
Whether we will grant the stay or not, that is also be looked into. Appeal to admit.
Not so far as stay is concerned.
Having heard the
I have
learned
averred-
advocate,
I have averred that not in the month of November there is the
okay, having heard the
opposite
learned,
party is going to solemnize marriage. So, my lord, on that score, I am.
okay, you prepare the paper book. Having heard the
Lord, if he solemnizes marriage, my appeal will become.
Stay application next day.
stay application.
There is a stay application.
There is any scope of passing any.
Lord, the difficulty is in the month of November he is going to solemnize marriage, and if he marries, my lord, my appeal will become invalid.
No, absolutely valid allegation. Clear evidence is there that the lady had no vagina, and doctor came and doctor adduced the evidence to that extent.
Okay, but you marriage was solemnized in the year 2012.
না ও বলছে কি এই যে বলছে মেনস্ট্রুয়েশনের প্রবলেম হলো বলছে ভাইজাই
No, doctor came and doctor told this evidence. Adduced the evidence to that extent. There is
লোকে শুনলেও হচ্ছে হঠাৎ করে
Yes.
পড়ে যাবে
There is structural defect and that is incurable.
চাইল্ড
Only.
না চাইল্ড বিয়ারিং ক্যাপাসিটি নাও থাকতে পারে
Yeah.
ও বলছে ভাইজিনা নাই
No, no, doctor came and adduced to that extent, evidence was there. MRI report is there. MRI doctor has also told the same thing.
বাবা, ঠিক আছে ভাই।
আচ্ছা তাহলে ইয়ে করুন তো, তাহলে ওই application
কোনটা? অ্যাপ্লিকেশনটা অন্যদিন দিয়ে দাও, ওদের তো একদিনেই ফি হবে। আজকে অ্যাপিল অ্যাডমিশন হলে একটা ফি হবে, আবার স্টে অ্যাপ্লিকেশনের দিন একটা ফি হবে।
আচ্ছা
মুখ
আমি
দেখে বুঝতে পারছেন?
আচ্ছা অ্যাপিলটা লিখুন শুধু, ইয়ে having heard the learned advocacy of perusal of the PA, I am aware of the view that the issue raised by the appellant in this present appeal issues will need to be addressed. Accordingly, appeal shall be heard. And will you prepare paper book? Acha, petitioner is directed to deposit the special messenger cost. Acha,
within 2 weeks করে দিন,
acha, to bring the TCR. Acha, within 2 weeks from date. Acha, up. Stop, acha.
The appellant is directed to prepare informal paper book after settle
receipt of notice of arrival of the, আচ্ছা within a period of,
না না ওটা করবেন না, ওটা ও করে নিন।
আচ্ছা ঠিক আছে,
ও ইনফর্মাল পেপার বুক to prepare the informal
requisite number
of informal paper book upon getting the index of the papers to be included in the informal paper book settled to the respondent. তারপরে হচ্ছে ট্রায়াল কোর্টের ইয়ে দিয়েছে তো, the trial court records, হ্যাঁ ওটা বলা হয়েছে, the trial court records shall be placed at the time of hearing of the appeal. ইনফর্মাল পেপার বুকে তো ডিপোজিশন গুলো দেবে, এবারে আমাদের যদি বুঝতে কিছু অসুবিধা হয় তখন হচ্ছে অরিজিনালটা থাকবে, উই ক্যান লুক ইনটু ইট,
যেটা আমরা করি আর কি সুবিধা হয়।
Mention the number of paper books to it.
Requisite number, you want one or he want one?
না না না, দুটো ডিপার্টমেন্টের দুটো, আর সার্ভিসের হচ্ছে সার্ভিসের একটা, ওর একটা, ছটা কি আটটা হয়।
Appellant is directed to prepare
রিকুইজিট নাম্বার করুক না, তাহলে ওরাই আপিল শোনানি হবে না।
Incorporating all the documents and all the evidence and documents brought on record by the parties before the learned court below. Stop. এবার তলায় লিখুন as paid for the hearing of this of the application being 10/1 of 2025 is adjourned to
Come tomorrow.
Tomorrow, are you ready?
Yes, tomorrow you have no difficulty, I think.
Lordship, in that case, I have to submit my affidavit in opposition. Give me 3 days time, Lordship. Then I will come back and show all the documents and all the evidence that has not been enclosed with the stay petition.
But in that event, then I am praying for an interim order. Lord, this stay application is.
No. Give me a minimum opportunity, Mr. Chaudhary.
You take much
evidence. You have not given the annexed the evidence.
I have not pressed the evidence. Lord, I have not pressed.
Mr. Das, if you take much more time in the circumstances, he will pray for ad interim order.
No, Lordship.
3 দিন চাইছে, ও বলছে এফিডেভিট দাও, আমি 3 দিনে এফিডেভিট দিয়ে দেবো।
So give it here.
ওই স্টে
অ্যাপ্লিকেশনটা লিখে দিন তো পিপলকে। আচ্ছা তাহলে ওটা কেটে দিন, অ্যাজ প্লেটফর্মটা কেটে দিন। আচ্ছা স্টে অ্যাপ্লিকেশনটা লিখুন। আচ্ছা মিস্টার দাস, লার্নেড অ্যাডভোকেট, রিপ্রেজেন্টিং দ্য রেসপন্ডেন্ট, representing the plaintiff respondent, acha, prays for leave to file affidavit in opposition to the application. ঠিক আছে, আচ্ছা stop, leave is granted. The acha, respondent is directed to file affidavit in opposition within
সোমবার দিয়ে দিন।
acha, within 16th
Lordship.
Within 16th, আচ্ছা reply if any be filed within?
Monday, my lord.
আচ্ছা,
17th.
within 17th.
Lordship.
ঠিক আছে?
17 18 দিন
হ্যাঁ।
with advance copy 19th এ রেখে দিন।
আচ্ছা, place the matter in the list.
20th is the last day.
Place the matter in the list for further consideration on 19th.
Lordship.
ওপরে লিখে দেবেন এপিডিও সার্ভিস।
I'm grateful to you, Lordship.
It's taken on record.
Grateful.
ওটাকে সাজিয়ে করে ও ইয়েকে দেখিয়ে দিও, ঠিক আছে?
340
হ্যাঁ,
into 20.
বেরোচ্ছি, দেখি আর কি আছে, আর অ্যাডমিশন কিছু আছে? কি আছে?
ট্যাক্স এন্ড টাইমার এসটি, দুটো এসটি আছে, একটা সিজিএসটি আছে।
দেখি ডাকি কে আসে দেখি।
Item number 12 under the heading Tribunal Appeals.
But can this be taken up tomorrow as the first matter? I have to cite some of the provisions.
Very well. We don't assure you it will be the first matter, but tomorrow we will definitely take it up.
Great.
এই বাবু, ট্যাক্সিং ম্যাটার দেখতে পারেন, ট্যাক্সিং ম্যাটার আর কিছু
বইগুলো মানে পেপার বুকটা সেকেন্ড
পড়ে দেবো একবার অ্যাপ্লিকেশনটা, এই যে 12টা আর 15টা, আর কিছু পাঠাবো 15 পিটিশনটা পাঠাবো।
চলো চলো, ডাকো 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 ডাকো।
Item number 13. Item number 13.
I'm paying for next week, Lordship, Monday, Lordship.
Yes,
Monday, Lordship.
everybody is asking for Monday. Come tomorrow. Not today, Koro.
Item number 14.
Lordship, in item number 14, I am appearing on behalf of the petitioner. This matter is being led by Senior Counsel Sri Dr. Debo Brotokaran, who is appearing online from Kolkata.
Yes, my lord, I am appearing, my lord.
Yes, you are for the appellant or the respondent?
Petitioner, my lord.
Appellant petitioner, we are for the
I am for
appellant.
the petitioner, my lord. In this case, during the vacation, my lord, the matter was placed before the division bench. My lord, in absence of learned advocates for the state respondents, my lord, the honorable division bench was pleased to refer the matter to the regular bench. This is a case of transfer, my lord. But a lady female assistant, my lord, a group D staff, has been transferred from, my lord,
Where is the other side? Where? Your other
lord,
side is not
from-
there. Your other side is not
My lord,
there.
on the last occasion also, they also already released me, my lord. In that case, my lord, kindly, my lord, protect me, my lord, so that no coercive action is taken against me, my lord, in the meantime. But
No,
what has happened, my
what-
lord, I am medically sick. I have annexed all the documents, my lord, for which, my lord, even I have been advised to admit to the hospital for an operation. But in this case also, on the last occasion also, what we have seen, the junior
Group D
junior
staff under which department?
health and family welfare department, my lord.
You check it up, probably in case of health and family welfare, under the rule, there is a stipulation that you should not be transferred to a place from where you cannot commute from your place of residence.
My lord, my lord.
You check it up, there probably one of the group D departmental, I have seen that in
My lord,
case of group D staff, you cannot be transferred to a place where from you cannot commute on regular basis from your residence.
My lord, he has been transferred more than 300 kilometers away at Dokkin Dinajpur, my lord.
From where?
Only because of the reason that, my lord, the petitioner, my lord, participated in the Arjikor protest. Only due to personal vendetta and vengeance, my lord, only this has
You
been done.
you check in one of my orders.
My
I
lord.
have a Group D staff residing in Howrah was transferred initially to Dhonekali. He did not object. Subsequently, he was transferred to Darjeeling. You look into my order. I have passed an interim order staying there. Because there is in the health department, there is a specific provision in the service rule that you should be transferred to a place from where you can commute. You check it up. You come.
My lord,
ট্রাইব্যুনালে চ্যালেঞ্জ দিতে এখানে ডাইরেক্ট চলে এসছে
কোনটা?
WPST. Whether you challenge it before the tribunal, where is the order of tribunal?
no, my lord, during the vacation bench, my lord, during the vacation, my lord, the tribunal was not functioning, my lord, for which, my lord, I prayed, my lord, leave, my lord, to file before the Honorable High Court.
You challenge it immediately.
না ও চ্যালেঞ্জ যদি করে নাও করে ও সিঙ্গেল বেঞ্চে আসতে হবে, ডিভিশন বেঞ্চে কি করে হবে? এটা ওই রবির কাছে গেছিল, এটা মেনশন করেছিল কি? This matter was mentioned.
My lord,
yes. I told you, Junior. Junior, that
my lord, I mentioned before the Honorable Justice Parthasarathy Chatterjee, my lord, my lord, for drawing attention of my Honorable Justice, my lord, the Honorable Justice Parthasarathy Chatterjee directed me to file the matter before the division bench, my lord. Only for that reason, my lord, I filed the matter before the division bench and make the matter as WPST. Otherwise, I would have filed the matter, my lord, before the single bench at that time, my lord. Kindly, my lord, consider.
I stated you that you mentioned during the vacation that tribunal was not functioning then. I stated that you approach that bench taking tribunal matter under 227. That bench is not available. You are holding superintending jurisdiction. You address this situation.
এটা কি হয়, আমার হচ্ছে ওই দেবে রজার ম্যাথিউস বা হচ্ছে ইয়েতে
yes, my lord, paragraph 392.
Roger,
paragraph 392, it has been.
I gave you the judgment. Roger Matthews.
My lord, yes, I have the judgment, my lord.
Roger
my
Matthews
is there, my lord.
See,
yes,
Roger
Matthews. 392.
Roger Matthews and Samuel Matthews.
Yes,
you
yes,
can,
yes, my lord.
If the tribunal is not functioning, you can
go.
You can invoke. It's not required. It's not required. আমি বললাম আবার আমাকেই দেখাচ্ছে।
Okay, yeah. What is the citation?
Citation of Constitution Bench 2020, my lord, volume 6, Supreme Court cases, page 1. My lord,
you have to go. You have to invoke the read jurisdiction. See, before the division bench, it is judicial review. If it is judicial review, then some order has to be there. Suppose you had filed before the tribunal is not operating, it has adjourned your matter. In that situation, you could have come before the division bench. But today you have not approached the tribunal. So you have to come in 226.
My lord,
before the Group 6 bench.
My lord, what has happened, my lord, on that date, my lord, the division bench, my lord, entertained the matter and was in a position, my lord, to pass an interim order. But as the learned government advocate was not appearing,
it will be without jurisdiction. It will be an order without jurisdiction because if you have to invoke the writ jurisdiction, it has to be. We are exercising judicial review. We may be exercising writ jurisdiction, but writ jurisdiction, we are exercising it as a judicial review over the tribunal. Today Group 6 bench, single bench. কেন এখানে তো আমরা জুডিশিয়াল রিভিউটা করছি, এক্সারসাইজ করছি। এটা জাজমেন্টও আছে যে সিঙ্গেল বেঞ্চ হবে, ডিভিশন বেঞ্চে অর্ডার না থাকলে হবে না। এটা তুমি ও যদি ফাইল করে আসতো তাহলে একটা ব্যাপার হতো।
my lord, at this precarious situation, my lord, kindly give me protection, my lord.
It will
So
be,
that
you go before the single bench, 226.
my lord, your lordship has power, my lord. Court
No,
has
we don't
enough
have power.
jurisdiction, extraordinary jurisdiction, my lord.
No, no,
to-
no. See, don't lift up to the Shohid Minar. If I fall from there, I will not realize whether I am dead or I am alive.
My lord, not that, my lord. Your lordship, my lord, is I am praying for on
this is-
humanitarian ground, my lord.
No, no
On-
humanitarian ground. Sorry.
My lord,
At least I will not pass an order where I don't have the authority. Plain and simple.
my lord,
Go before the group 6. We are giving you leave.
in some of the cases, my lord, we see full bench judgment, my lord, is taking the repetition of the single bench along with my lord the larger bench matter. There is a special bench judgment in the case of my lord district inspector of Calcutta versus
See, Mr. Koron, we are not interested. You know that hydraulic jacks, you know about hydraulic jacks? They use fluid to pump up. Don't use fluid to pump us up.
my lord, only my lord, because of the my lord serious illness of my client, my lord, I am praying, my lord.
See, suppose you have a brain tumor.
My lord,
and
in the meantime, my lord, I shall go to the tribunal, but my lord, kindly, my lord, give me protection not to take any coercive action, my lord, against me, my lord.
Sorry. You have a brain tumor, you go to the orthopedic or
My
the
lord, more than
gynecologist.
300 kilometers away, my lord. I have been transferred more
You
than
may have
300 kilometers away.
You may have a good case, take down.
My lord, at least, my lord, give some protection, my lord. So,
Huh?
in the meantime, my lord, I shall
ট্রাইব্যুনাল এসে গেছে
tribunal
single member functioning. Single member functioning.
why did you
I shall,
file it?
my lord, I shall approach the tribunal, my lord. My lord, in the meantime, my lord, give protection not to take any coercive action, my lord.
No. Sorry.
My lord, then at that time, and money in that case, my lord, I have to join, my lord. My lord, at this stage, my lord, I am referring a prescription, my lord.
Please now allow us to pass the order.
I beg to be apologized, my lord. I beg to be apologized, my lord. Disturbing you, lordship, my lord. My lord, I am referring a prescription, my lord. My learned junior will give. I in my heart, my lord. My lord, my learned junior, my lord, kindly, my learned junior will refer the prescription, my lord. That is that date, my lord, 962025.
Not required. Take down. The petitioner.
All right, this situation, at this precarious situation, my lord, kindly, my lord, on the ground of equity, at least, my lord, earlier division bench entertained the matter. If the earlier division bench, my lord, to file it before the single bench, will not. I would have held before the single bench, will not. But the division bench did not do that. The division bench referred the matter before the regular bench, my lord. For which, my lord, I am now in a soup, my lord. Kindly, my lord, kindly.
You are in a soup. Let us don't drag us into the bowl of soup.
Yeah.
Take down. The petitioner is admittedly an employee under the government of West Bengal and placed in the health department.
Health and Family Welfare Department.
Health and Family Welfare Department. The petitioner has been served with a memorandum of transfer.
And release order also.
And
I have been released.
And a release order from his present place of posting, which is assailed in this judicial review. The petitioner did not approach the West Bengal Administrative Tribunal, being the regular forum for ventilating his grievances. It is true that the Honorable Supreme Court, Roger Matthews to diye sab ye.
2024, page 1.
Has said, has held that in the event the tribunal is not operational, the aggrieved person may approach the jurisdictional high court by invoking writ jurisdiction on Article 226. In the instant case, since the petitioner alleges that the tribunal is not operational and as such has approached the court at the first instance, the petitioner was required to invoke, was required to approach the single bench having jurisdiction under Group 6 of the classification list. This application for judicial review before the division bench therefore cannot be entertained, since there is no order of the tribunal which can be the subject matter of the judicial review. The petition being such and such is therefore disposed of, granting the petitioner liberty to approach the appropriate forum. The petitioner shall be entitled to get benefit of the time spent between
27/5/2025.
From 3rd June 2025 till date, আজকে date দিয়ে দেবে, for having prosecuted bona fide before a court without jurisdiction.
My lord, at least for 10 days, my lord.
No, sorry.
1 week, my lord. I am praying for 1 week, my lord. Kindly, my lord. 1 week. My lord, I tender apology, my lord.
আর কিছু আছে?
My lord, Mr. Justice Parthasarathi Chatterjee, I tender apology, my lord. I beg to be apologized, my lord.
Item number 16. My lord, the conducting appellate, my lord, the conducting counsel is undergoing certain medical treatment, my lord. If it could be fixed next circuit.
Mention it tomorrow.
Tomorrow. Item number 16, may I request to fix the matter on next week?
Sorry. No mentioning at this stage.